Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on panel for all 6 cases we'll be hearing today are Justice Ariane Vuono and Justice Vicky Henry. The first 3 matters will be criminal matters. Following the conclusion of the argument in the 3rd criminal case, we will take a brief recess and resume with the civil portion of the list. The first case on our list for hearing this morning is case number 2020 P608, the Commonwealth versus TRUONGTAM PHAM. The Commonwealth has a motion to transmit exhibits from the clerk's office of the trial court, and I would like to attach to that motion are high-resolution photocopies. I take it the defense has no objection to the use of those photocopies in lieu of the original exhibits?
No objection.
All right. So we will enter that on the docket, and we will work with those materials. Mr. Benyon, you may proceed.
Mr. Chief Justice, and may it please the court. So I think anyone who has significant experience, any jurist who has significant experience with criminal cases, particularly drug cases, is going to have real question about this conviction. I know you've read the briefs and are familiar with the facts. You have the transcripts before you, but I just want to highlight a couple of points. This is a case where 2 cars pull up. My client is in the second vehicle. He gets in the first vehicle, and it's that vehicle that's then detained by the police. It seems pretty clear that if you look at all of the facts as were brought out at trial, Mr. Vuono was in the process of purchasing drugs, but it does not look like he actually purchased anything. If you look at the facts, the driver of the car, Mr. Knopford, when he was pulled out, there was crack cocaine there, baggies, plastic baggies, a scale. The other person in the car had fentanyl and I believe some crack cocaine that he was attempting to hide. When Mr. Vuono was pulled out, the police did see him trying to stuff something into the seat cushion. When they retrieved it, it was a bag of fentanyl. The police officer who testified as an expert witness was able to give testimony as to what that bag might cost. And it looks like Mr. Vuono had almost the exact amount of money needed to purchase that. So it doesn't look like any purchase actually occurred. We don't really know what happened in this case because the police went and grabbed the vehicle really almost immediately after Mr. Vuono got in.
The conviction was for possession with intent to distribute, correct?
Yes.
So whether he had, whether your diagnosis of the situation is accurate, and this was in fact an aborted purchase, the fact that he had not yet paid for the fentanyl that he was, at least a rational jury could infer, he was stuffing into the seat pocket. He was in possession of that fentanyl, correct?
Well, he was not in possession of it in the legal sense. In other words, he had it, but he couldn't exercise dominion and control over it.
Well, I'm sorry. I'm going to have you unpack that for me just a little bit, because he had it in his physical possession and he stuffed it into the seat pocket, correct?
Yes.
What portion of that does not equate to control?
So under the legal sense of dominion and control, it's the ability to own the bag. It's the ability to possess and take away and do whatever you want with the bag. I mean,
Benyon, let me pose, just to change the facts ever so slightly, and let's say the police had not moved in, and Mr. Vuono had decided that he wanted to save himself some money, and after receiving the bag of fentanyl from let's say the seller, he opened the door and ran off with the fentanyl. He would not have acquired ownership in the legal sense by having paid for it
True.
But you would not seriously challenge the premise that he was in possession at that time.
Well, again, it depends on what we're talking about with possession. Physical possession is one thing, but possession of something to have dominion and control over it, to take it, is something different. In other words, oftentimes when a purchase is being made, a person who is selling it will hand it over to the prospective buyer where they can inspect it. This is almost any commercial transaction, not just a drug transaction. And while the person might physically have it in their hand, I don't think anybody would say that they have it, that they possess it and can do whatever they want with it.
Can you, Attorney Benyon, could you point me to a case in which our court or the Supreme Judicial Court has held that when someone is actually holding drugs, has physical possession of the drugs, they do not have control over the drugs?
Well,
they're not exercising dominion and control.
So that's what I would think dominion and control means.
But is there a case in which we have someone has physical possession and we have held that did not equate to, or the jury could not rationally infer dominion and control?
So again, I'm not familiar with a specific case that says that, but when the courts use the words dominion and control, that's something different than mere possession.
So this would be the first case to adopt your view of what dominion and control means.
I don't think it's my view. It's the law's view of what somebody can do with something that they.
Well, maybe the disconnect here, excuse me for interrupting, is that when we talk about exercising dominion and control, we're almost always talking about constructive possession, right? We're not talking about physical possession.
Well, constructive possession means that you have physical, or you have dominion and control, but you might not have physical.
Exactly.
Of it.
Exactly. It seems to me you're conflating the two here.
No, I don't think I am, because when Mr. Knopford hands over the drugs, if this is what indeed occurred, if Mr. Knopford is selling it and Mr. Vuono is buying it, when Mr. Knopford passes the bag to be inspected, I don't think he's giving up dominion and control. He's just.
That's not what happened here. What we're talking about is your client being observed stuffing the drugs in the seat pocket or in between the seat cushions at the time that he's pulled out of the car.
I think he's just merely hiding the drugs because the police are rushing the vehicle. I mean, just because he's hiding them doesn't show that he has dominion and control over the.
He had physical possession because he was seen with them in his hand before he put them in the seat pocket.
He was, but he still has the money in his pocket for the drugs. He hasn't.
Well, you know, I have not challenged you on that yet, but that is one view of the evidence.
It is.
The seller also had money in his possession, so it's possible that he had Mr. Vuono had more money. You know, again, but
it is possible. But the problem here is that
let's adopt the novel view that we'll take the evidence in the light most favorable to the defendant instead of the light most favorable to the Commonwealth, just for this moment, and accept the premise that he hadn't yet paid for the drugs. Again, Justice Vuono points out that that physical possession does not require dominion and control because physical possession is physical possession.
Again, I think with respect to a drug deal, had Mr. Vuono attempted to take the drugs away without paying for them, I think that would have, I mean, just because he has possession of them doesn't mean he has control.
Just because he has possession doesn't mean he has possession. I understand the argument. If you want to move to the, I thought that your principal challenge here was going to be on the idea that he did not intend to distribute. But if you want to,
that is. I'm just trying to
possession. That's okay.
It is. So under the law, you need plus factors that show that he has an intent to distribute. And in this case, there is nothing there. What we have here is an aborted, what we likely have here is an aborted attempt to purchase drugs. There's nothing that shows that Mr. Vuono would take those drugs and redistribute them.
Other than the correspondence that he had with a purchaser earlier in the day before he arrived at the scene of his purchase.
Well, again, what we're talking about is those text messages were received, and mainly what the government uses as plus factors in this case are the text messages that occurred before this buy.
On the day of, which illustrate that he had gone to they show his intent in acquiring the inventory. That is, of course, even to the extent that you wish to characterize them as prior bad acts, that's one of the exceptions. And they're probative of his state of mind in purchasing the again, the would-be inventory to sell to his buyer.
But there are many reasons why a person would buy a large amount of drugs. They could be for personal use. They could be what is oftentimes kind of a mixed personal use or redistribution. But in this case, we don't know.
I take it that those alternative scenarios were argued to the jury.
Well, they were alluded to. I think I'm not. As I went back over the transcript, I think they were alluded to. Hold on, let me just.
My point is that the jury is free to adopt a different view of the evidence than the defense would wish them to.
That's true, but it's your court's purpose to make sure that the proof is beyond a reasonable doubt, and the jury is not just being prodded to convict on a lesser standard of just, for example, out of an abundance of caution. In this case, when you have the police rushing the car and likely interrupting the sale, it's difficult to know what would occur had the police just allowed the transaction to occur. It's difficult to know what Mr. Vuono would have done if he would have succeeded in purchasing the drugs, and whether he would have redistributed them or not. What the government uses to push the jury into believing that the particular drugs that he was purchasing were going to be redistributed was the prior bad acts. And in this case, it's the problem with those prior bad acts is they are prejudicial. They do.
The most powerful evidence always is prejudicial. I mean, there is, as you know, an exception to the general disfavor of prior bad acts, assuming that we are going to treat these as prior bad acts, to show intent, state of mind, motive, or pattern.
Well, if we're talking about pattern, the trouble is it has to be
about state of mind, at least on the day of, and intent, because intent is, of course, at the heart of this case, intent to distribute.
Right, but the problem is it's a slippery slope. I mean, you're asking the jury to say, hey, well, once a drug dealer, always a drug dealer. Maybe
no,
not.
I'm asking the jury to say that when he's got someone saying to him, are you going to get me some stuff today? And then he goes to the seller in this car to get the stuff, that he's doing so for the purpose of delivering to his customer.
So which text message are you looking at that says, are you talking about of the day?
Yes.
Are we in exhibit 15D, right? That's in the exhibits. Is it 15D?
Let's
because as I look, those text message calls, I mean, they don't occur on the day of the transaction. They end 2 days before.
What would you think would be the outer bound? Because some of the text messages were 2 months before.
Exactly. Again, you are on a slippery slope when you are pulling things in, and mainly the police officer was talking about things that occurred two months before. But again, if you're crawling inside this man's head, things that occurred 2 days before don't necessarily show what was occurring on the day where he was apprehended. He might have already, I mean, maybe he did sell the drugs 2 days before, and maybe the transaction was finished. But when it comes to those drugs that day, that's what he's on trial for. And the trouble is when you have all the evidence in front of you, you don't know what he's going to do with those drugs. There are no plus factors. The only thing the government does,
the Commonwealth will say that a trooper testified that the amount of drugs was consistent with distribution. Would that alone be sufficient to sustain the verdict?
well, that depends on how you want to set beyond a reasonable doubt as. I mean, I don't think it is personally because, you know, there are people who buy in bulk. There are drug dealers who buy in bulk because they'll support their own habit, or they will, you know, they'll sell some and keep some. You know, in this case, we don't know any plus factor that would show what Mr. Vo would do with those drugs on that day.
But Attorney Binion, the expert witness here, the police officer, was actually cross-examined on that very point. So the jury was aware of the fact that, of course, it's possible that someone buys in bulk. Doesn't that then become an issue for the jury to decide what kind of weight to put on that evidence?
It does, but surely you're not going to say that just because a jury decides something, you can't review it to determine whether it's beyond a reasonable doubt. That's a standard this court is supposed to look at. And while a jury gets first bite at that apple, you get to look at it and make sure and determine whether the standard is high enough. Beyond a reasonable doubt is supposed to be a standard that's high enough to prevent the government from making mistakes and putting innocent people in jail.
And
Even innocent people who do bad and stupid things.
In conducting that review, what is the standard that we apply?
Well, the standard is I put that in my brief, what the legal standard is, and yes. Can I finish the question? I see my time's up.
Yes, go ahead and finish.
The difficulty is it's beyond a reasonable doubt is subjective, sir, and you're going to set that standard at a high bar or a low bar, and in this case,
in accordance with Lattimore. And I know that you have that in your brief. Thank you, Mr. Bennett.
Thank you.
For the Commonwealth.
Good morning, Your Honors. May it please the court, Monica Delatorre on behalf of the Commonwealth. The Commonwealth is respectfully requesting this court to affirm the defendant's conviction of possession of fentanyl with intent to distribute. I'm
going to anticipate a question that you're likely to get from at least Justice Henry, if not also from Justice Vuono, and that is the text messages from 2 months before the transaction.
Correct. So here the text messages, regardless of whether this court characterized them as bad acts or not, here there's no question that they were not used for propensity purposes. I would first point the court to the instruction that was given when the text messages were admitted. That's on pages 43 to 45 of the February 8th transcript. The trial judge in this case repeated that the jury could not use those the text messages as basis for the propensity of the defendant, and that the defendant had committed crimes based on the past actions.
This question is not original to me. I'm going to paraphrase a former Justice of the Appeals Court, Nick Flannery, who dealing with one of these cases went to one of his colleagues and said, please explain to me again the difference between pattern and propensity.
Well, the pattern here informs the jury of the defendant's intent to distribute on the day of the incident. How that evidence is used. There is a pattern, I understand that, but it shows that the defendant had access to drugs. That shows that there's a familiarity with those items. It shows that this is not an absence of mistake or an accident by the fact that the defendant has this amount of drugs on them when the police detain the defendant and the other members in the car.
Okay, and in all of what you just said, what in that is also not propensity?
Well, they're used for the purpose of intent. So in the way that the evidence was used here was not to say that the defendant had a character of being a drug dealer, and that is why he has the fentanyl with possession of intent on the day of the incident. They instead are saying that in the text messages are admitted with the conjunction of the expert testimony. So the expert testimony highlighted what the terms were that were used in the terms of the text messages, in terms of those being consistent with text messages that are coming from a user to a dealer, as opposed to the other way around. But the text messages discuss the denominations that are common in terms of fentanyl, whether it's 100 or 40. The expert also testified that the terminology in terms of coffee, referring to the color of fentanyl, in terms of that being how users can request that from a dealer. So it's consistent.
Can we get to a basic foundational question, which is, what was the most recent text message in relation to the date of the transaction?
So I would note that the text messages, there are two different groups of them. There are those that are on the day of the incident, and there are those that are up until from about 2 months beforehand until April 12th, which would have been 2 days before the incident. So they were separated. The text messages and the phone calls on the day of the incident, there were numerous text messages and phone calls between the defendant and the driver of the car that the defendant.
But were any of the text messages that seem to indicate distribution on the day of, or even with the, let's start with the day of?
So on the day of, there are mostly phone calls and then text messages from the driver in terms of planning to meet.
Right, that's why I'm asking whether there's anything that indicates distribution, not the purchase.
Well, I think that it's indicating the planning in order to meet with the driver.
Is there any text? When are the dates of the text messages seemingly between someone this defendant would be selling to? Because those definitely are at least some of those are 2 months old. So I'm wanting to know if there are any that are the day of or very close to the day of.
Not from the individual that's in the car. Those are only from the day of. But the most recent in terms of requesting from the defendant to purchase are as recent as April 12th, which is 2 days before the incident. So for example, there's a few text messages from an individual that's BUU3 who's asking for a 30, saying that he can bring 100.
Record appendix page for that?
Excuse me. It was not a record page. It was filed with our motion to transmit exhibits. The exhibit number is 15D. It's on page 89 of that exhibit.
Do we have that exhibit then?
It is filed with the Commonwealth's motion to transmit the exhibits.
I have it on page 88 and 89 on exhibit 15D attached to the motion to transmit exhibits.
Okay.
That individual in particular had discussed requesting a $100 bag. And again, the expert had testified that that's a common denomination for requesting fentanyl. The defendant had texted back saying to give him time and that he would be there in an hour. So there is a back and forth exchange that's up to 2 days beforehand. That's April 12th of 2017. And the incident in question.
Assume for a moment that the most recent text message of someone seeking to buy drugs from the defendant was 2 months earlier. Would they still be admissible?
I think they would be. I mean, I think that the judge here did a careful analysis to figure out if that would have been too long. The cases were, if there is no specific time limit on when this type of evidence is no longer admissible. I don't think that would have been too long here. That is the longest date in terms of February. And then it's all of February and then April, excuse me, were the months that were admitted. But here, the judge here did a careful analysis. She thought 2 months wasn't too long. She gave the instruction that they couldn't be used for propensity. So here, I don't think it's an abuse of discretion for the judge to admit those text messages for the purposes of the jury to be able to evaluate the defendant's intent on the date of the incident. If there are no further questions on the text messages, I do just want to note in terms of the sufficiency here in the light most favorable to the Commonwealth, primarily the finger of fentanyl. The expert had testified that the amount of grams that were next to the defendant, that 9.22 grams, was consistent with an amount that a dealer would have rather than a user. Indeed, even a half of it.
Would that alone be enough? Would just the quantity be enough to convict him of intent to distribute?
Yes, a large amount of drugs alone can support that inference. I point the court to Commonwealth versus Steffius. It's 468 Mass 160 that holds for that, a 2014 case, excuse me, and Commonwealth versus Humberto H, which is 466 Mass 562. Both of those hold for the proposition that a large amount of drugs alone can support intent to distribute. And here I would suggest that's the case.
A large amount, but in most of those cases, we're talking about a significantly greater amount. I mean, I understood that the expert said that this is consistent with distribution, but this is not, a kilogram, for example.
It's true that's not a kilogram, though the expert had also testified that even half of a finger, which would have been half of the amount that the defendant had, would be on the extremely high end of personal use. This is a large amount of fentanyl. And the expert had also tested that it would have sold for roughly around, I believe it was $600 on the low end, $2,400 on the high end in terms of how much that was worth in terms of sale. So it is a significant amount. I understanding that it is not as much in terms of a kilogram, but if my understanding of those cases may have been cocaine and other types of drugs that may be sold for a lesser amount. So here, this is a considerable amount of fentanyl. In addition to that fact, which I would argue is enough on its own, there's also a couple of additional facts that show the intent that are sufficient to show the intent here. The one being that there's a significant amount of money on the defendant, where the defendant noted that they were unemployed, and where there is a large quantity of money, and here in the denomination that's consistent with how fentanyl is sold, it was in denominations of $42 $20 bills and a couple of $10 bills, that supports an inference of intent to distribute as well. This is in addition to the text messages that's already been noted, the absence of drug paraphernalia, and a few, multiple cellular telephones that were on the defendant, as well. So with all of those facts in combination in the light most favorable to the Commonwealth, there was sufficient evidence to find the defendant guilty of possession with intent to distribute here.
So you say on page 33 of your brief that the defendant argued there were only two possibilities of what was happening in the car. Either the defendant was selling the drugs to the people in the car, or he was buying the drugs from the people in the car. You say in your brief this does not review the evidence in the light most favorable to the Commonwealth. Could you explain what is the light most favorable to the Commonwealth then?
The light most favorable, the Commonwealth had argued here that this was a dealer-to-dealer transaction. So here in the light most favorable to the Commonwealth, the defendant had this fentanyl, had potentially received it from those in the car in order to deal that fentanyl and had the intent to distribute that fentanyl. There's no evidence of anyone handing the drugs back to the defendant or anything like that. There's no evidence in terms of what had occurred in the car, but the defendant certainly argued that theory. But here in the light most favorable to the Commonwealth, the defendant had that fentanyl with the intent to distribute in terms of the amount. I'm happy to answer further questions, in particular about the expert witness as well, if the court has any.
I guess the question I have is, if the text messages show that there was just one person that this defendant was supplying with fentanyl, just one, would that be sufficient for distribution?
If the text message only shown one person, I think that would
usually with a drug dealer, you see text from many, many people, right? So I'm just, if there's just one person consistently, is that sufficient?
I think that would be sufficient as well. It may not be as strong of a case, but again, we're talking about sufficiency. So the strength of the case going to the jury and for the fact finders to determine. I think that would be sufficient. Here, again, we have a number of text messages coming in, not just text messages coming in, but text messages in response by the defendant as well, responding to those requests for fentanyl as well.
So defense counsel says there are no plus factors here. What do you say to that?
I think in addition to what I've already sort of alluded to in terms of sufficiency, that in addition to the fact that the amount of fentanyl is so considerable in terms of the 9.22 grams, the defendant having money consistent with the sale of fentanyl when the defendant stated that he was unemployed, where there are two cellular telephones on the defendant, we have text messages consistent with distribution rather than personal use, and an absence of drug paraphernalia. And we know all of those being plus factors towards and being sufficient to find the defendant guilty of possession with intent to distribute. I'm happy to further ask further questions. Otherwise, the Commonwealth will rest on its brief.
Seeing no further questions, thank you both for your argument. The case is submitted.
We're live.
The next case on our list for hearing this morning is case number 2020-P606, the Commonwealth versus James A. Finn. This is the defendant's appeal. Attorney Hagar, you may begin.
Thank you, Your Honor. Good morning. May it please the court. Thomas Hager for Mr. Finn on this case. We have one issue on appeal. It's pretty straightforward. We have to determine whether or not there was sufficient evidence to determine if there's an indecent assault and battery committed by Mr. Finn on Susan. In order to find indecent assault and battery, we need to show intentional touching, the justification or excuse, and the touching was indecent. With respect to intent on part of the individual, we need to show the person not only touched to put the individual, but it's on a manner of had a conscious purpose to touch the private parts in a manner of touching private parts for that reason, without justification or privilege. And we don't have
Preliminary procedural question. Are you challenging sufficiency at the close of the Commonwealth's case, the defendant's case, or both?
We can argue both, but I'm really going to focus on the close of the Commonwealth, at the close of all evidence. I'm arguing both, but I'm going to focus most of my argument on all the evidence as a whole, including the defendant's case. With respect to that, Your Honor, our point is as a whole, in looking at the evidence as a whole, the defendant's evidence deteriorated the Commonwealth's evidence to such a point that we feel no rational juror could find him guilty of an assault and battery. Susan indicated that he touched her private parts, says like a penis, said it twice. It's not correct in that situation. It is what it is. We feel strong that her evidence and her credibility is weak, in which case could be overwhelmed by the defendant's case. She indicated that.
Repeat what you just said. I'm not sure I caught it.
Our position is that Susan's testimony, her credibility is weak, and the Commonwealth's case as a whole is weak to a point where it can be deteriorated by the defendant's evidence.
Are you suggesting that you can lodge a challenge to the sufficiency of the evidence based on the defendant's case calling into question the credibility of the defense of the prosecution's key witness, the victim?
You can, in this case, you can, because not only is it weak, he provides evidence to qualify her testimony. So it's not really.
Isn't what the question which testimony to credit a classic prerogative for the jury?
You want, yeah, on one level, you correct. Yes, Your Honor. However, this situation, he qualifies the testimony. So my opposition is not so much the fact that it's yes or no, he said, she said type of situation, is that he qualifies and her testimony. And that's our position.
The jury is not required to credit anything that he says.
Well,
they can ignore it. They can treat it as being false, or they can treat it as being true. But there is nothing that the defendant can say that can cause the jury's ability to attach weight and credibility to the victim's testimony that can cause that to dissipate.
Well, yeah, I don't disagree. I think if the defendant brings evidence that's strong enough to carry the Commonwealth's case, then I think the defendant's entitled to a required finding at the close of all evidence. That's our position on the matter. So on one level, I understand your point.
So if the defendant takes the stand and says, "Don't believe the victim, she's lying," that calls the victim's testimony into question, and you're entitled to a required finding.
Oh no, the defendant can't just control the case with saying I didn't do it and gets to walk out of the courthouse. No, of course not. I'm not saying that. What I am saying is Mr. Finn's testimony qualified the touching in a manner which it was an accident as opposed to.
Yeah, but the jury are not required to believe him when he says that, are they?
Well, as I see it in the case law, Your Honor, if he presents evidence that was strong enough to deteriorate the Commonwealth's case, then it shouldn't go to the jury.
But just answer my question. Simply because he says it doesn't mean that the jury are required to believe it, right?
If he says he didn't do it, maybe you're correct.
No,
but
if he offers an alternative, innocuous, exculpatory explanation, the jury are not required to believe that, are they?
I differ, Your Honor. I think if he qualified,
you don't have to agree with me on that point, but you are going to have to point me to some law that says that, because I think there's a fairly rich vein of decided case law that supports the jury's prerogative to ignore the defendant's alternative version of facts.
Well, yeah, I think. Well, my position, ladies and gentlemen, is that he qualifies the position. It's not like he's saying it didn't happen. I think it's.
He's certainly entitled to say that, and the jury are entitled to ignore him when he does so.
Well, okay, well, then we have to differ on that. My position on
Okay, well,
I think if I may
Agree.
intervene and ask you, Attorney
Sure.
Bickett, the kinds of cases that I'm familiar with in which a defendant's case deteriorate, so to speak, after presenting a case, generally involves something along the following. The defendant presents evidence. I was incarcerated on January 21st, 2021, on the date of the alleged offense. I could not have committed it. And with that kind of evidence is evidence that a judge might consider to be strong enough to show that the defendant was not available or able to commit the crime. But I have to say upon occasion agree with Chief Justice Green that I don't know any line of cases that, other than something that in the affirmative nature of an alibi type defense, that would entitle the defendant to a required finding of not guilty after he or she has presented a defense.
Yeah, I understand that point where that's in the other extreme. My position sort of is that the defense position is the Thomas case is not overly strong, and obviously we may not take a lot to deteriorate it. So it's not a situation where we may need as much as we otherwise would need. And because your testimony basically was there were 6 charges, and the jury didn't believe 5 out of the 6. And Susan's testimony we believe is not credible, was weakened. It was not as strong as it otherwise could have been. She made statements about how Kelly was touched, what happened to John, and those were consistent with the other witnesses. The police officer's testimony was all over the place. So we just feel that basically, given the fact that Susan's testimony may not be as strong as it otherwise could have been, testimony was credibility was in question, may require less from the defendant to deteriorate the case. And that's sort of up.
Do you agree that the testimony, that the conviction could rest on the testimony of one of the children, even if it was not corroborated?
Yeah, corroboration normally, yes, sure. There's case law indicating that that's all you really need. You don't have to have 5 witnesses coming in and backing it up. With reference to corroboration, I think that would simply go to the fact that it would make her testimony not being corroborated may go to the issue of the strength of a case. And so far as John was there next to her, he didn't see it. So the corroboration would go to the issue of the Commonwealth's case being that much a tick or 2 weaker than otherwise would have been. But normally, you're on this case law indicating that you don't need corroboration. You don't need 7 people to back her up.
So in a nutshell, if I understand it correctly, your position in this appeal is that the victim's testimony was not terribly powerful, and that the defendant's explanation of why the incident was not criminal so weakened the victim's testimony that the jury could not rationally assign credibility to her testimony.
Exactly. Thank you. That's sort of my position. Yes, Your Honor.
I think we understand your arguments.
Yes, that's what it comes down to. Essentially, that's what the case was not as strong as we'd like to have been. Regarding Susan's testimony, she made a few mistakes. The jury didn't find the case as a whole. 5 out of 6 charges not guilty. And that being said, they contradict each other a lot. And Mr. Finn, he basically did not say I didn't do it. He said, this is what I did. And maybe it was an accident. I touched it. I don't know what happened, but he qualified his testimony, his statement at the police station. And because he qualified it and didn't directly contradict Susan, but he expanded upon it, we feel that that would sort of further expand upon the incident, describe why he had justification to go on there and pull it back. And one other thing, Greg, on strict liability, I know my sister cited a case of strict liability. I don't know if it's set, but I would not feel comfortable with having strict liability be the standard on decent assault and battery. Maybe with rape, it's one thing, but decent assault and battery has to, strict liability has to do with consent. So I feel a little uncomfortable applying strict liability to a case like this. So the charge of assault and battery, there should be room for mistakes or justification or excuse that we can't just simply say, if you touch somebody, you're guilty. So I would add my point on that. But otherwise, Justice Green basically capitalized our argument, and we just don't feel the case is strong enough. Looking as a whole together, that no jury could find him guilty. I would ask the court to arrest the conviction. No further questions. I'll rest my brief.
Thank you.
Thank you.
For the Commonwealth.
Good morning. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honors, there was sufficient evidence that the defendant intentionally and without justification touched the 8-year-old victim's vagina over her clothes, where she testified that the defendant touched her penis while she sat in his lap. At the close of the Commonwealth's case, based on the victim's testimony alone, there was sufficient evidence in the light most favorable to the Commonwealth that supported the charge and would support the charge going to the jury. The defendant's
just on a preliminary, I think you agree with this, but I just would like to confirm that the touching was of Susan, right?
Yes, that the touching that was for which he was convicted was exclusively of Susan. And the Commonwealth would suggest that it's based on Susan's testimony. And at the close of the defendant's case, the case law is clear that the Commonwealth's case cannot deteriorate based on credibility determinations. That is alone for the jury, and that is in part because the court is required to view the evidence in the light most favorable to the Commonwealth. So in this case, when the court was considering whether to submit the evidence to the jury after the defendant testified, the correct analysis would be assuming that the jury entirely discredited the defendant's version of facts, would there still be sufficient evidence to send the case to the jury? And in this case, again, based on Susan's clear testimony about the intentional touching, there was sufficient evidence to send the case to the jury. A proposition that the defendant is arguing for would simply allow many defendants in many different kinds of sexual assault cases to get up on the stand and say, no, this is how it happened. I'm qualifying what the victim has told you. And that's just simply not the state of the law. It's not the role of a judge to make credibility determinations. It's exclusively the role of a jury as the fact finder to credit, discredit, partially credit all the witnesses' testimony.
So you argue in your brief that the defendant's own theory, of reaching out and holding on to the child so she wouldn't fall out of a chair supports that there was an intentional and deliberate touching. Do we have to agree with that to affirm?
I do think you need to find that there was testimony that it was a deliberate and intentional touching. I think that Susan's testimony would suggest that would survive. Based on her testimony, she said the defendant, while she was sitting in his lap looking at pictures of naked women, the defendant put his hands on her penis. So Susan's testimony suggests it was an intentional touching, and the defendant's own testimony also suggests this wasn't an accident. This wasn't he didn't trip and accidentally touch the victim. The victim didn't accidentally run by him and he brushed her. This was an intentional touching in the term.
To answer Justice Henry's question, you don't require any weight to be assigned to the. I understand your position that the defendant's testimony was inculpatory on the question of intent. But even if we were to disregard the defendant's testimony, even if the defendant didn't take the stand, your position, as I understand it, is that the victim's testimony alone is sufficient to support a conviction.
Yes, exactly, Your Honor.
But if someone was trying to stop a child from falling, which I will say happens every day, and they do intentionally grab the child, but they, the kid is falling, so you don't necessarily know exactly where you're going to catch them. You're not saying that kind of touch would be an indecent assault and battery.
No, Your Honor. It's one of the elements that the intentional touching be without legal justification or excuse. I would say in that case, it would be the Commonwealth's burden. And in this case, it was the Commonwealth's burden to prove that there was no legal justification or excuse for the touching. The defendant, because of the defendant's testimony, because of his claim that he touched her 3 inches above the vagina on her stomach, I don't think that the defense counsel really, he did not argue that point in his closing. So I would just say that of course there are legal justifications and excuses for touching that the law provides for, but this case, based on Susan's testimony, does not qualify. And if the panel has no further questions, the Commonwealth is happy to rest on its brief.
Seeing none, that will conclude the argument in this case. The case.
We're live.
The next case on our list for hearing this morning is case number 2020 P236, the Commonwealth versus Juan DELVALLE. And just as a reminder, we will take our morning recess after the conclusion of the argument in this case. Mr. Zindrasky, you may begin.
Thank you. May it please the court, my name is Matthew Zindrasky. I'm here for Juan DELVALLE. I'd like to start with my sufficiency of the evidence argument. Argue that there was insufficient evidence corroborating Mr. DELVALLE's statements that he had operated his motorcycle. The statements in particular was that he was coming from the waterfront, a bar, and that he had just stopped to urinate in Springfield. There was insufficient evidence corroborating it where there was no other evidence of operation, where the trooper doused, the arresting officer had not checked if the motorcycle's engine was warm. The keys were not in Mr. DELVALLE's possession. And while he apparently was found urinating by Trooper Doused, there wasn't anything corroborating any kind of time frame where he was found. That Trooper Doused had been stopped in downtown Springfield, filling out some paperwork for a ticket, and had only noticed Mr. DELVALLE when another car had illuminated him against a building.
So the defendant, the Commonwealth argues that the defendant was near a motorcycle that had the key in the ignition, and that the defendant was wearing a helmet, and that all provided corroboration of his statements that he had been riding a motorcycle. What do you say to that?
That is true. I would say that doesn't provide corroboration of any kind of time frame that he had been riding a motorcycle. He could have been preparing to ride the motorcycle with his helmet on. That it's not.
Let me interrupt, because there was just one more piece of evidence, and that was the fact that the defendant acknowledged to the trooper that he had not made any other stops along the way from the waterfront to where he was on the street in Springfield, which was about a 10-minute ride or so. Does that tip the scale slightly, so to speak? And
I would say that doesn't particularly change my argument, where the length of time that he could have stopped is still at issue, where there's no other evidence of operation. So there's nothing for the engine being, for example.
He didn't live on that street, right? And the jury couldn't. It was close to midnight at the time that this happened, right? At the time of the stop.
Yes.
So, do you think it's unreasonable for the jury to infer that he had done exactly what he said he did, which was he was coming home on his way home from the waterfront, and he stopped to relieve himself?
I would say without more. I think it's close, but without more to show that he had recently stopped, without any other independent evidence aside from his statements.
But he stated that he stopped for a particular purpose. A rational juror could infer that when he stopped for that purpose, he did so because of a rather imminent need, and that when the trooper saw him urinating, not much time had passed between the time that he said he stopped and the time that he began to relieve himself. He's still wearing the helmet, and the keys, as you point out, were not on his person. In fact, they were in the motorcycle. I guess we have to decide what a rational jury could conclude from that set of circumstances.
I would point to the fact that the officer was located nearby and hadn't observed Mr. DELVALLE operating that motorcycle when he was close enough to see him.
Well, if he had seen him operating the motorcycle, we wouldn't be having this conversation.
Can you say that again? I'm sorry.
I said if you had seen him operating the motorcycle, we wouldn't be having this conversation. The question really is whether the defendant's admission to having operated the vehicle is sufficiently corroborated by the things the trooper did see. And again, what we have are the keys in the bike, the defendant standing next to the bike, wearing a motorcycle helmet, and urinating, as he had said was his purpose in stopping the motorcycle after he had been operating it.
Yes, well, I think it's clear he had been operating the motorcycle at some point. But pointing to the trooper being present nearby shows that he hadn't been immediately operating the motorcycle while the trooper was present. Trooper had.
But he's impaired, and he's just come from a bar. Now, I guess my question to you is, what is the alternative set of facts that doesn't have him operating the motorcycle that he said he stopped in order to urinate, and was seen urinating? What is the set of facts that would mean that he wasn't operating the motorcycle while impaired?
I think that he had somehow gotten intoxicated while he'd stopped. There was a bar located nearby, and so.
You're saying that bar was within walking distance?
Yes, the trooper testified it was about 100 yards.
And his purpose in stopping to urinate, he decided not only to urinate, but he was going to go and get drunk before urinating. Is that the idea?
I think that's putting a lot of weight on what his statement could mean.
I'm just trying to understand the theory that you're asking us to conclude the jury should have adopted instead of the Commonwealth's.
He could have done other things in addition to stopping to urinate. That his statement to the trooper is not dispositive of everything he might have done.
So he told the trooper, "I'm stopping. I needed to stop to urinate." But instead, while the trooper wasn't looking, he stopped, and before urinating, went to a bar, consumed enough intoxicating liquors to become intoxicated, returned to the motorcycle, and before he left the key in the motorcycle while he was doing all of that. And before getting back on the motorcycle or before doing anything else, he urinated, as he had initially said that he was proposing to do when he stopped.
Essentially, yes.
So I understood that you were basically saying that he drank at the bar that was nearby, that he walked back to his motorcycle as anyone would walk back to their motor vehicle, started, he put the key in, and then decided he needed to relieve himself, and he hadn't ever gotten on the motorcycle. I thought that was your theory.
Well, I'm saying there's not sufficient evidence of what had happened. So I think that's a possible theory as well, that essentially there's really.
Well, that was all there. And we know that the trooper, I think the trooper would have been alert enough to notice him ride the motorcycle, because he was only 10 feet from the motorcycle, right?
Yes.
So at that point, where that plausible scenario is present, that the Commonwealth needs to confront that in its evidence.
Yes, that is essentially my argument, that the lack of observations from Trooper Doust before noticing him be illuminated, there's a lot that could fit into those moments that we don't know. He could have been drinking at the bar. We just don't have any information. So that's why I argue that the evidence is insufficient, especially where he hadn't checked to see if the motorcycle was warm. I think that would have that's a critical piece of information here, where the motorcycle, we don't have any information about that.
If the defendant inserted the key into the motorcycle without turning the engine on, would that suffice to constitute operation?
Yes, but I think in this case we don't really have any information about.
I'm just going back to the sequence of events that you are suggesting the jury should have adopted in order to find the Commonwealth's evidence insufficient. Because if he went to the bar before urinating, he would have had to, and became drunk at the bar 100 yards away, he would have had to have left the key in the motorcycle while he did so.
Essentially, but again,
he returned in an intoxicated state. He's operating under.
Yeah, well, there's no information when the key was in the motorcycle.
I understand that, and so I'm just trying to figure out the sequence of events that viewed in the light most favorable to the Commonwealth, that the jury is to adopt from the evidence that we do have.
I think essentially, yeah, that he must have then left his key in the motorcycle.
And instead of urinating, gone to get drunk, and then come back, urinated, and not gotten back on the motorcycle.
Well, there's a lot of information that wouldn't be there. I think why it would be an insufficient information argument. We don't know what the the condition of the bar, et cetera, things like that. So I'd like to the insufficiency does lead into the other arguments I've made, because they all deal with a substantial risk of a miscarriage of justice, but where the operation is, I think, the contested issue at trial, essentially, where Trooper Doust had engaged in improper opinion testimony as to Mr. DeValle's guilt of operating under the influence.
One question I had, sir, is that let's say we agree with you that the trooper's testimony with respect to the field sobriety assessments was a bit overboard, was a bit too scientific in nature, et cetera.
Okay.
And let's even assume that we might say that was a substantial risk of miscarriage of justice. Doesn't that all go to the element of impairment and not to the element of operation? So if we were to determine that that this case rises and falls on the issue of sufficiency of the evidence on operation, do we have to really address what the trooper did or did not do in his expert test, in the testimony he gave before the jury?
I would say that the trooper had also himself, through his testimony, connected the field sobriety test with the actual operation of a motorcycle, where he testified. I actually had the page 104, but it's 102. I had a typo in my brief, where he had testified that the field sobriety tests are to determine whether or not a defendant has been operating a motor vehicle while impaired. And so the trooper himself has testified or connected the idea of field sobriety tests to operation. And so while it does bear more on impairment, it is connected through his testimony as well. And then the remainder of the argument, similarly with the bike night and his testimony that he had formed the opinion that Mr. DeValle had been operating the vehicle and he was impaired, both also go to operation, and both were improper statements of opinion of his actual guilt, and the Commonwealth has conceded that the closing argument was not based in any facts at trial, that Mr. DeValle was coming from bike night.
How does the Commonwealth also on the concession about bike night suggest that that statement, that misstatement, was not probative of any question in the case, and it was not prejudicial?
Well, I would say that I think that it is probative of operation of a motorcycle, that he was to be coming from bike night. There's an inference and an implication that this was an event involving motorcycles.
You're standing next to a motorcycle wearing a motorcycle.
Right. And if you're from Western Massachusetts, you might know what bike night involves, which is hundreds of motorcycles at one particular place, right?
Right. Well, it's just another error that goes to the substantial risk of the operating of the motorcycle. Just, it does tie him closer together with the motorcycle. He was found near his motorcycle. It's not a major.
That it was his motorcycle?
The Trooper Doust did testify that he ran the registration, and it did come back as Mr. DeValle's.
One last comment about bike night. I noticed that the Commonwealth mentioned bike night in the opening statement as well, and there was no, there didn't seem to be any comment with respect to that. Do you think make the comment about bike night in the closing even more prejudicial, or I don't suppose you want to say it was less prejudicial, but can you illuminate that point?
Yeah, I did mention it very briefly in my brief, but that it did reinforce the opening.
You know what? I apologize. Then I missed that. I saw it when I read the transcript, and I just didn't see it in the briefs. I apologize.
One sentence, I think, but it does, I think, reinforce hearing that he came from bike night in opening and closing, and then not having it brought out at trial contributes to the error, makes it more prejudicial. If there are no further questions, I can rest on my brief.
Thank you.
Thank you.
For the Commonwealth?
Morning, and may it please the court, Joseph Colliflores for the Commonwealth. In terms of sufficiency of the evidence, it is true that we cannot have speculation or surmise for the proof of operation, but here with the defendant's statement that he had just ridden from a location, there is evidence that the trooper observed that confirms his statement that he just rode there and stopped to urinate.
Well,
The panels
counsel, this case is interesting in the sense that the trooper was actually pulled over writing up some paperwork. So he had been there for a little while. And so we have the statement of it that the man had been from the waterfront. But on the other hand, didn't just pull up, because I find it hard to believe a trooper would not notice a motorcycle and is not aware enough of his surroundings. That would make a trooper very much vulnerable. And we have another bar that's within easy walking distance. So does the Commonwealth have to deal with that at all?
I think certainly it would be prudent for the Commonwealth to head off such an issue, but I don't think it is necessary. There's no evidence of a particular time frame that the trooper is parked there. He said he was parked and wrapping up some paperwork from a previous stop, and that he had worked I don't have it in front of me, but I believe it's an 11 to 7 or 11 to 8 shift overnight through the midnight hour. So at the furthest, we have an hour. At shortest reasonable time, I'd say he's been sitting there for 10 minutes. In either event, the evidence that's presented is that he's sitting there and a car drives by and reacts to the defendant peeing against the building. Now, the evidence that the trooper actually observed, as the panel mentioned, is he's already peeing, he's wearing a helmet, the keys ignition. Additionally, there's also gloves that are on the motorcycle. And I'd like to key on to the helmet and the protective eyewear that he's wearing. It's a warm night and it's around midnight, and nobody's really wearing protective eyewear for a motorcycle walking around a street at midnight unless you are driving or riding a motorcycle. Now, there's been a talk about how familiar somebody is with a bike night, but if someone's familiar with the operation of a motorcycle and helmets, there's full helmets that cover the chin. There's half helmets, which kind of just wrap around the top half of the head, which would require wearing protective eyewear while wearing that kind of helmet. So it is clear that while he's peeing, he is wearing the helmet, he is wearing the protective eyewear, coupled with his statement that he had just ridden. There is sufficient evidence that is not based upon speculation to confirm that statement and to find that he operated the motorcycle. Moving on, if there are no questions on operation, I just want to briefly touch upon the Canty and the quote unquote value added language. This case is very different from both Canty and Leary, where in Canty and Leary, the officers that testified connected the two questions of operation and impairment, that those defendants did operate while impaired. Here, the operative statement is that he had operated and that he was impaired, not that while he was impaired. So it's not
You characterize that as being disjunctive. I'm not familiar with reference to the use of the word "and" as being disjunctive. I always thought that "or" was disjunctive and "and" was conjunctive.
I'm not talking in a strict grammar sense, but he's saying it as two different statements. He's not using a while instead of an "and," in which I'm trying to distinguish from both Leary and Canty. It'd be one thing to say that he was impaired while driving the motorcycle versus he was impaired and there's evidence that he operated the motorcycle. So that still leaves the conclusion, the ultimate conclusion, up to the jury to determine whether or not his impairment at the time of the field sobriety test was also closely related to his operation of the motorcycle, if that is proven.
So why
you distinguished Leary and Canty, but just to go back for a moment, in both Leary and Canty, despite the error, the convictions were affirmed, right?
That is correct.
We're assessing this, assuming we disagree with you, and that we conclude that the trooper's testimony was improper. We're reviewing this for substantial risk, right?
That is correct. Both these statements, as well as the closing argument and opening statement reference of bike night, are unobjected to on the record.
why was the trooper allowed to give any opinion on operating a motor vehicle?
I'm not sure, Your Honor. The question was asked and it was answered without any objection. On the record, there's nothing clear why such question and answer was allowed. It wasn't approved by the court. It just came out in the nature of the direct examination of the trooper.
So on this issue about bike night, I think the defendant is arguing that the statement goes to the very issue of operation of a motor vehicle. What do you say to that?
I can see the argument that it does go to operation, but I think the distinguishing character of the fact that it is from bike night has really no bearing on whether or not he actually operated the motorcycle. If we take away the fact that he's coming from an event at the waterfront, he's really admitting to operation of the motorcycle. So whether or not it's from the waterfront or from some other location, it is not really amounting to much. There is a reference or an inference that can be made that because he was coming from bike night, that he was riding a motorcycle, but I don't think that is necessarily prejudicial in this case, where he's already admitted to operating the motorcycle coming from the waterfront. He said to the trooper, "I just came from the waterfront." He initially denied having drank anything at the waterfront and momentarily admitted to smoking marijuana. But later on, and I apologize for not including this, he does admit that he had drinks at the waterfront. So whether or not there's an event, a bike night, without any further explanation of what bike night entails, if he was there for showing off his motorcycle or if he was there as part of anything actually related to bike night, I don't see how this fleeting reference to bike night prejudices the defendant, especially when there's curative instruction saying that the evidence is from the question and answer of the trooper and your memory and not opening or closing arguments.
That's the general instruction. There was not a specific targeted curative instruction as to that reference because there was no objection.
That is correct, Your Honor.
The defendant's argument is that the reference to bike night ties the defendant more closely to this particular motorcycle.
I mean, Your Honor, he's already tied pretty closely to it. It's a motorcycle that's registered in his name. There's no reference of anyone else in the vicinity. He's wearing a helmet. His gloves are on it. It's registered to him. He's there. He stops peeing and he starts walking back towards the motorcycle. I don't think
he puts the key in the motorcycle and does not turn on the ignition and then walks away. Is that sufficient for operation?
The case law holds that anything that tends to put a motor vehicle into operation is sufficient. And I would say that putting it
but if he never put his leg over the seat, he never put his hands, otherwise never put his hand on the motorcycle. Motorcycles are a little different from cars. How would that go to show operation?
I think I would disagree that it's a little different than cars. Maybe in the aspect that one is normally how they're seated on the motorcycle versus in a car. But other than that, the operation of a motorcycle is very similar to a manual transmission motor vehicle, where you have to put the key in the ignition, you have to make sure that it's in neutral, you turn it over, and then you put it into first gear to initiate movement of the vehicle. Once again, we don't know when he put that key in the ignition, and that Commonwealth admits that could be at any time frame from 0 to the trooper's initial stopping in that spot. But when he puts that key in the ignition, the car is set in motion, or starting to be set in motion, to be operable. Now, the key can be put in while you're not seated, or the key can be put in while you're seated, but that's a weight issue for the jury to determine. If there are no further questions, the Commonwealth would rest on its brief.
So when the trooper testified that the field sobriety test had been validated to a worldwide standard, is that accurate?
That statement is not supported by the actual record in this, and I personally have no knowledge of how worldwide it's been validated. I know that it's NHTSA here in the United States is offering it, but I'm not familiar with the actual validation standards of the field sobriety tests.
So you would say it's validated nationally?
At a minimum.
Okay. Do you, if someone had objected about the validated clues language, do you think the judge should have sustained that objection?
I think it's a dangerously close kind of statement, the quote value added or quote unquote clues, and that's coming out of Horn. If I were a judge, I probably would say, back off that kind of language. But I don't think it's prejudicial here. And I don't think when we're looking at such language, it's a close call. When we're looking at Commonwealth v. Gerhardt in the marijuana discussion, there's a quote that the concept that it is a test may not be necessarily removable from this kind of testimony and field sobriety tests. And inherent in that kind of statement that we can't remove the testness of the testimony, then we're also looking that there's necessarily a rubric or an answer sheet to such a test. I would suggest that this language here, that it's validated clues, is referential to his training. Indeed, that's the first time that he mentions the word value added, is when he's discussing his training to the field sobriety tests. Without any additional explanation of what those clues are or how they operate, I would suggest that it's just purely reference to his training. In the Maryland District Court case, Horn, they went into length talking about the HGN and the horizontal gaze nystagmus. And here we don't have any testimony, real testimony about HGN. It was almost elicited, but then backed off by counsel. HGN, if you read Horn, requires a lot more medical testimony to connect it, and it's often not used here in Massachusetts due to the nature of the testing. So without any added scientific language of what it is, of what the value add is, or delving into any more scientific characteristics of the field sobriety tests, I don't think that this rises to any level of prejudice from the testimony.
Going back to the issue of operation, if you had someone who was using a car instead of a motorcycle, but someone had, say with the door even closed with the window down, had leaned into a motor vehicle, into a car, and put the key in the ignition, but never entered the car, would that be sufficient for operation?
Is it just in this hypothetical that they put it in but did not turn?
Yes.
I'm not sure if that's ever been played out in the jurisprudence, but I would argue that it is sufficient, just because that tends to put the car in motion. Now, obviously, it's not a very good operation if they're leaning in.
Yeah, so now we all have these, many of us have these smart keys where you get in the car and you could push the power button, but you don't actually push the power button. Is that operation of a motor vehicle?
Well, once again, I think it delves into the characteristics of the car. In my keyless vehicle, you have to press the brake for the car to actually turn over and start. If I push the button while the key's in the vehicle, it turns on to accessories or an on position, which allows the electronics to be operated. Once again, it's tending to put the car in motion. I would argue that in those kinds of circumstances, it's a close call, and it might be factually dependent on how a person is seated or non-seated at that time. And once again, I would suggest it's a jury question of whether or not the intent of the person was to put the car in motion. There are no further questions.
Running out of time, and I think we've run out of questions for you. So that will conclude the argument in this case. The case is submitted, and we will take our morning recess. Thank you both.
Thank you, Your Honors.
Number is case number 2019 P1730. Attorney Sirotkin Butler for the father. You may begin.
Thank you, Your Honor. I will admit that I am deeply disturbed by this case, both the failure to obtain jurisdiction before terminating parental rights and the 1-year delay as the serving father, and the extraordinary delay by the trial judge of 334 days between trial and docketing her findings. Counsel for the child and I collaborated on energetically seeking to get the findings docketed so that the appeal could go forward. I will also say that there is a strong impact from the reality that Massachusetts is the only state of all 50 states to have failed to enact the Uniform Child Custody Jurisdiction Enforcement Act. And I have reason to believe, although not total data, that this impacts many cases across the state. The history of this case in the Boston Juvenile Court is concerning for many reasons. The North Carolina statute with regard to jurisdiction, which is provided to this court in my addenda at page 111, and the retention and termination of jurisdiction statute of that state, also supplied to this court in my addenda at page 112, were not apparently followed. The goal was changed to adoption before father was even served. It took over a year for this father to be served. There is no evidence that father was notified of trial dates. There is no evidence.
Let me ask you this, if I may, Attorney Butler. Your client was aware of the fact that there was children, and he had children, and they were living in Massachusetts, correct?
What my client was aware of is something that I can't be fully aware of. I do know that at the initial hearing, he drove up with his aunt, apparently, based on what was in the transcript. Mm-hmm. And his aunt testified, who had held custody of these children 3 times in North Carolina and was approved in North Carolina, and continued and continues to be willing to provide a home to all 3 of them. Father did not remain in the courthouse and subsequently filed papers in North Carolina last year, in which he stated that his legal domicile remained North Carolina at all times, that he only voted in North Carolina, and that he did travel back and forth to Massachusetts. To what extent he was fully aware in our discussions, he really thought that his aunt was going to be succeeding in having custody. There was a North Carolina order that was live at the time that
but that order did not concern the child in this case, correct? It was the older 2 siblings.
Well, that's not clear. That child had been born for 7 months at the time the order was issued. That child,
it was not, but am I correct that the child was not named on that order?
No, he was not named, but he received health insurance as specified in that order. He received visitation as specified in that order. He was not specifically excluded in that order. And any efforts I made to get information from North Carolina were just stymied. What correspondence I received from the North Carolina employees was included in this appendix.
Right.
Well, so though you're saying that the child did receive the health insurance and the visitation, but had, say, for example, the father not complied with that order, would he be able to argue that the child, because the child was not named, that our order did not cover the child?
Your Honor, I'll never know. It would appear that that child received services under that order because the order provided housing to the mother.
Well, is there any record evidence that the court knew that this child existed? I understand that he was born, but that doesn't mean anybody told the court.
Your Honor, again, I made strenuous efforts to get the North Carolina docket sheets. I provided those efforts. I did not succeed. I can't tell you what North Carolina knew and didn't know. That's not a question that I have the data to answer. What I do know is that the mother and the children resided in housing that was ordered by that order.
But at the time of this case proceeded, the mother and the children were residing in Massachusetts. This child was not named in the North Carolina proceedings, and the judge consulted with the North Carolina judge and entered a report establishing for the record that the jurisdiction over the youngest child, the child involved in this appeal, was properly in Massachusetts.
Respectfully, Your Honor, although the judge made that statement, not one document was provided in support. And whatever discussions may or may not have occurred, the parties were not notified, they were not present, and there was no record.
The record is the report that the judge made. I am not aware of a requirement, and maybe you can point me in the direction of one, that the parties participate in those consultations between judges in alternative jurisdictions around the establishment of jurisdiction in a sister state.
Your Honor, North Carolina has such statutes. And again, one of them is 50A110. It is present in the addenda to my brief at page 111. It has that requirement. Another is the North Carolina Retention and Termination of Jurisdiction statute provided in my brief at page 112, which requires that the parties be notified that either they be allowed to participate or to submit information and that a record be made. There is no documentation that that occurred. And this court has held in Anisha that mere statements by counsel are not evidence. Yes, the judge made that statement. No, there is no record support for it. And I find that troubling. This court may not find it troubling. I do.
There's a difference between statements by counsel and a statement by the judge, I suppose. And the question of whether there is an entitlement to notice and an opportunity to participate is a different matter.
Your Honor, respectfully, Santosky versus Kramer was well aware of the ability of state agencies to control cases. And at page 758 of Santosky, the statement is made, admittedly in a footnote, that undue uncertainty with regard to potentially dispositive facts is a due process denial and renders the right to counsel and multiple layers of hearing essentially an illusion. Here we have a statement that a judge has determined that there is jurisdiction over a child, despite the fact that the other court with whom they are speaking has requirements in its statutes that these things be done in a certain way, and there is no evidence of record that that court and an elected judge followed any of those statutes.
What difference does that make for us?
This child was not a subject of those proceedings.
I'm sorry, I couldn't hear either of you because you spoke at the same time.
All right, the chief can go first and I'll follow up.
This child was not a subject of those proceedings. The Massachusetts statute that governs jurisdiction in this case prescribes the process that was followed. You may have the concerns you raise. I understand, but the statute authorizes precisely what was done here.
Your Honor, respectfully, the statute is an apparent conflict as it was in care and protection of Vivian, as it was in Delk versus Gonzalez, that where a prior state has apparently exercised jurisdiction, there is a need for comity. And
No, but where is the apparent exercise of jurisdiction over this child in North Carolina?
this child only saw his father in accordance with North Carolina orders. This child resided in the placement ordered by North Carolina. This child,
The fact that he was affected by orders, affected indirectly by orders that entered in a different proceeding to which he was not a party, does not place him under the jurisdiction of the North Carolina court, unless I'm missing something.
Your Honor, respectfully, again, referring to Sandhosky at 758, there is a certain lack of clarity in that statement. Certainly a 7-month-old could not speak up and say this thing or that thing. However, every aspect of that child's life was controlled by orders of another court. And
Let me interrupt you and ask you this, because I think there's some other issues that are looming here that we're not acknowledging. My understanding from the record of this case is that your client was not on the birth certificate of this child, and that paternity was not established until the time that he was living in Massachusetts. Am I understand that correctly?
Your Honor, as with many aspects of this case, it's not so clear. There was an adjudication here, but my client tells me, and I can only give you what I have. So
I only want to know what's in the
Please give
record.
us what we have in the record, yes.
I don't have the North Carolina record, so I don't know what's in that record.
But you didn't say that these findings by the judge here were clearly erroneous, right? There's no challenge to any of the findings of fact by the judge in this case.
There was a challenge to the fact that all the record evidence of my client's relationship with all 3 children was positive. Every visit was good. He was affectionate and nurturing. There were not concerns about the visits. The children wanted to see him, and yet
There's no findings of fact that contradict. Well, there are some, and apparently there was some physical reactions at some point to trauma over the visit. There were some findings along that regard. So, are you saying now that those findings are clearly erroneous?
what I am saying is that the evidence of record is that the visits themselves were good. And as to the reason for any subsequent behavior, was it loyal?
Yeah, I'm asking a very specific question. Is there a finding of fact that you are challenging as clearly erroneous? Because that would really help me out to understand exactly which findings of fact by the judge in this case that you are alleging or challenging as clearly erroneous.
I am not challenging the descriptions of behavior as clearly erroneous. I am saying that it is not proven what the reason for them were, which is
so I'm clear. So that there's no challenge to in that regard. Thank you.
right. I'm not challenging.
And you're not challenging. You're also not challenging the findings as they relate to paternity.
No, I'm not.
Okay.
I am saying, however, that the full record was not available to me despite my best efforts of what occurred in North Carolina, and despite my ongoing battle to get documents, which included going into the courthouse on New Chardon Street, being assigned a sanitized room and hand scanning documents, I was not able.
Well, certainly your tenacity in the face of the pandemic is commendable. I'm going to say that if I may, because these are very challenging times, and I can well imagine how much harder it was for you to have access to those documents given the situation.
To answer those questions fully, and I could not gain access to all the documents I needed from the sister state. To that end, I also provided what online documentation I could get of how many times the 9-story Durham County Courthouse was shut down by COVID. They were struggling. I was struggling.
Right, but of course, all this information will not be able to be presented to us because it's on appeal. You can raise the issue of jurisdiction now, of course, but the efforts that you made and were stymied, that was to obtain information that would have to somehow be a reopening, or someone else would have to reviews those documents. Is that fair to say?
No, Your Honor, because as United States versus Ruiz shows, when subject matter jurisdiction and its basis is at issue, the appellate court sits de novo. And so as to jurisdiction, at least, and these questions go to the heart of jurisdiction, my read of the law was, had I been able to get these documents, I would have been doing my job as an officer of the court to get this court everything needed.
I understand. I don't want to take you over your time. But your point is that we could have reviewed those de novo. And I think Justice Henry has a few follow-up questions. I didn't mean to take up so much of the time.
I just had one question, which is that the department says that the aunt was not qualified for adoption. It only qualified as like a foster home. Do you contest that?
I do.
Could you point us to anywhere in the record that would help us figure that out?
I would point the court to the inclusion of ICPC 7, Section 6, and the fact that expedited review and placement under that was authorized by the first judge in this case, and I was unable to determine why the ball was dropped.
Thank you.
Thank you. I think we'll have to leave it there. I see that your time has come to an end. Attorney Dent.
Thank you, Your Honors.
Thank you. Attorney Dent.
Yes, may it please the court, Special Assistant Attorney General for the Department of Children and Families. First, Your Honors, with respect to contact, I would like to direct your attention to the finding of fact number 20, which shows that the department made many attempts to contact the father throughout the duration of this case and found those attempts unsuccessful. He became involved in 2014, and then he began engaging with services. And he also, the department contacted him at the time of trial, but failed to be able to get contact with him. And because of that, the judge drew a negative inference from his absence. Turning to jurisdiction, the 2013 order does not involve the child subject to this appeal. As you guys have noted, the child is not captioned in the order, nor does the judge discuss the child within those findings of fact. And the judge in that court explicitly discusses the 2 older siblings. And the fact that the judge discusses the 2 older siblings and not the child subject to this appeal, it shows that if the child subject to this appeal would have been subject to the order, then the judge would have discussed him in the same way that he did his siblings. Because of this, the only statute that the juvenile court had to consider with respect to jurisdiction was the Massachusetts Child Custody Jurisdictional Act. Under that statute, the juvenile court has jurisdiction if 2 prongs are satisfied. That is, first, whether or not the court has jurisdiction under Section 2, and then secondly, whether a mix of the statutory factors under Section 7 shows that the judge should exercise its discretion to exercise jurisdiction. In this case,
I'm going to pause you though here. I'm paraphrasing the father's counsel perhaps more sharply, but she's going to say, well, what happened here was we had a judge-to-judge conversation where the North Carolina judge may not have been following North Carolina law, and they just say so, that there's jurisdiction here and there's no way to review that, so you're just stuck with it. So why is that wrong? Because that's wrong.
Because first, Massachusetts law determining over jurisdiction should control this case. And secondly, Section 7 of 209 shows that if an issue of jurisdiction is raised, then the juvenile judge in its discretion, may exchange communications with another judge and have conversations.
Do we need to worry about whether that other judge is complying with their state's law at the time?
So Massachusetts has always had jurisdiction over the child subject to this appeal.
So does that mean that the judge-to-judge conversation is beside the point?
In this case, there's really no issue of jurisdiction because the child was brought to Massachusetts in October of 2013, and he lived continuously with either his parent or someone acting as a parent. So the state conclusively had home state jurisdiction. With respect to the conversation that was had, that was more so pertaining to the two older children. And in any respect, the judge in the juvenile court followed what is required under the statute, where that they had a discussion with respect to whether or not there was jurisdiction.
And that's not reviewable, basically, is what I'm understanding you to say. How would you get review of that conversation?
The statute doesn't require for any specific record other than the fact that they can have the discretion in its discretion. I would like to point the court to ENID versus Anastasia, where in that case, there was an issue of jurisdiction and it was resolved just by a phone call.
So one of the things that's interesting in this case is, normally we do look at jurisdiction over the child, but here, because of the way this unfolds, we've now separated this child and made it very difficult for the child to have any visitation with the siblings or other biological family members. Does that cause any concern for us?
So a guardian ad litem was appointed to look over the department's adoption plan, and the guardian ad litem found that separation was in the best interest of all three of the children because of the significant trauma that they have endured, that there are significant behavioral and mental issues and so it's best for them to be separated because they need the individualized support of a supportive caregiver. And also it is noted that in the child subject to this appeals interview, he noted that he did not want to live with his siblings, but he wanted to visit with them. And that's on page 237 of the record. I will no further questions on jurisdiction, or I'll continue the jurisdiction discussion with respect to, I've stated how this juvenile court had home state jurisdiction under Section 2. Now I'll move on to how the court properly exercised its discretion with respect to balancing the mix of those factors. As I stated, Massachusetts was the home state. There's no other state that has a stronger connection with the child since he was brought over in 2013 and has lived here continuously, and the majority of the information pertaining to the child's past and future care is in Massachusetts. Moving on to unfitness, even though the father does not really challenge this in his brief, the record fully supports the juvenile court's findings that the father was unfit because of his unabated domestic violence issues, in addition to the fact that he failed to adhere to the numerous service plans that were available to him. And to date, while there were many services with respect to domestic violence, he only completed one, which was the Nurturing Fathers program. And so it shows that he has not remedied his problems with respect to domestic violence and anger issues. And also, as the judges have noted, with respect to visitation had a very bad impact on all three of the children. With respect to the child subject to this appeal, started having temper tantrums, started stuttering. All of those stops once the visitation stops, and therefore clear and convincing evidence shows that the father is unfit. In respect to the department's adoption plan, which fully serves the child's best interest because the child has been in that placement since 2014 and is very bonded with that parent. The department will rest on its brief with respect to those issues and also defer to the arguments of Children's Counsel.
Thank you. For the children?
Thank
or
you.
for the child rather.
For the child. May it please the court, Sherry Krasner on behalf of the child. I asked this court to affirm the judgment, and I also asked this court to affirm the judgment promptly. When the trial in this matter occurred, my client was first beginning kindergarten. He is now about to end second grade. And that was after this child came into care when he was 18 months old. He's now over 8 years old. And after the determination, after the department changed its goal for this child to permanency through adoption, it took another 3 years before the trial ever began. So if there's one thing that I agree with counsel for father, it's that a prompt resolution of this case is called for. And I thank the court in advance for doing that. With respect to jurisdiction, I think it's been covered a lot, but let me just say very briefly, counsel's argument rests solely on the fact that the word children is used in the consolidated order that applies to the two older children. She has not pointed to anything else. And again, there are two captioned children in that order. There are two separate docket numbers that seem to correspond to the dates that those two children were born and came into custody. There simply is nothing on the record that is before us that would support the idea that this child, who was born in January of 2013, that any dependency proceedings began for him prior to September of 2013, when custody of the two older children was returned to mother. There simply is not any.
Although I understand that a tremendous amount of time has passed, but if we were to go back to the beginning and jurisdiction were to be raised immediately after the children were removed, wouldn't that weigh in favor of North Carolina having jurisdiction over all three children rather than separating these children by hundreds of miles?
It seems like it would be nicer, but that's certainly not what the law would provide for. There had been no orders in North Carolina. So if Massachusetts said to North Carolina in 2013, in 2014, rather than in 2020, would you defer to Massachusetts because the children are all here? I think you would have gotten the same response from the North Carolina judge, that there never was a dependency proceeding as to my client, the youngest child, and therefore we have no position. We don't have to defer because we have nothing to defer about. I also, Your Honor, counsel did file a motion to file a supplemental appendix, and I filed an opposition, and the motion wasn't acted on, and it was referred to this panel. I filed an opposition, first of all, because as the appellant, I don't believe that counsel could ask for a supplemental appendix. I think she could ask to amend the appendix. I oppose that motion, but upon reflection, there may be some things that have developed in that record that it may be useful for this court to see, and that would put that issue of jurisdiction to rest as far as my client. So if the panel wants to review counsel's motion, treat it as a motion to amend her appendix and have those more recent documents come in so that this court can make a final determination, that's certainly something that this court could do, although I still rest on the sense that there is no evidence that there was ever the North Carolina DSS was involved with this child. There's indications in the record that occurred, but the Department of Social Services in another state providing some sort of services to mother, having a clinical interest in the case is not the same as a legal action in that state, such that this court should be determining that still an open jurisdictional question. I also wanted to, Justice Henry, you asked the question about the adoptive placement, the aunt not being approved. It's finding 64 in the judge's findings, where she makes the finding that the aunt in North Carolina had only been approved as a foster placement and not as an adoptive placement. And it also was true that there seemed to be, and it's not clear from the record why it was taking so long in North Carolina, but once father came up to Massachusetts, he was at that point no longer interested in the aunt in North Carolina being a placement resource. He came to Massachusetts after mother's death, and he wanted the children custody to be returned to him. So toward that end too, I would also say that the fact that father is now raising for the first time on appeal, the fact that the judge did not consider the aunt in North Carolina as a placement resource, that first of all, it was not raised below, so this court should not even be considering it now. But if the court is willing to consider it now, there's simply no evidence that supports that. The judge made findings that the department had considered the aunt, but because of the special needs of the children, that it would not be, it would prove to be too much for the aunt. Each one of the 3 children had very profound special needs. The father's trial counsel did not even ask a single question of the adoption worker at trial, and he did not introduce any affirmative evidence about a competing plan. So I would say that that issue is not properly before the court, or if the court is willing to consider it, there certainly isn't sufficient evidence for the court to find any error. Insofar as the visitation, and counsel alleges that there was a bond between father and this child, I do not believe the record supports that in any way. There's a suggestion that father did not see this child during the 7 months that they were in, or the 9 months, strikes out the 9 months they were in North Carolina, and then he did not have his first visit with the child in Massachusetts until sometime in the spring of 2015. The record certainly supports that there were some good visits, that father was appropriate during visits, but the record also supports that father was not consistent.
Attorney Krasner, I'm sorry. I see that your time has concluded. So unless there are questions from the panel, we will conclude the argument in this case. Thank you.
Live.
Sorry, Archangelo, you said we are live?
Yes.
Okay. We continue our hearing list with case number 2020P 823, Fran and Diane's LLC versus 331 Lafayette LLC and another. You may begin.
May it please the court. My name is Gary Matsko, and I am here on behalf of the appellant 331 Lafayette. We are here, Your Honor, asking that the court vacate a judgment under Chapter 93A entered below by Judge Fahey on what was essentially a breach of lease case. And in fact, it was a breach of lease case in which the concurrent jury found no breach. We think that the verdict or the judgment must be vacated for 2 principal reasons. One is that the facts on which the judge relied to establish a 93A violation when measured against current case law cannot amount to a 93A violation. Secondly, even if that were not the case, every single element of damage that the judge awarded is based in large measure and could not be reached without a large measure of speculation. And so the damages are all clearly erroneous and not supportable by the record. If I might turn first to the 93A liability, and I know the court invited us to avoid the facts, but the analysis does depend on a few key facts. One is that the lease in issue in this case was one that was initially for 2 years, but permitted renewal, specifically requiring a written notice 6 months prior to the expiration of the existing term. That notice was never given. Secondly, that when 331 Lafayette acquired the property, they were the successor owner, not the original landlord. They were aware of this record, and a record that showed that there had not been any proper extension, and concluded that the lease had become a matter of tenancy at will, and commenced eviction proceeding after a proper notice. Ultimately obtained a judgment and an execution. That judgment and execution, the judgment, excuse me, was later vacated by the appellate division. But at the time that the 331 pursued its eviction and conducted an eviction with the sheriff, it had a valid execution that had not been stayed. The other component of the judge's 93A foundation was that during that time period when 331 was pursuing the eviction, it was also pursuing demolition of adjacent properties it owned. It did so pursuant to valid permits that had been issued by the city of Salem, never once being cited for having done anything wrong in the demolition process.
So counsel, I take it nobody argued claim preclusion because the appellate division did at some point reverse?
They did not, but it wouldn't have been claim preclusion. It was a summary judgment decision below. What the district court did, what the appellate division did, was remand, Your Honor, to back to the district court for a trial, but it was moot by the time it had been remanded back. So essentially what was going to be remanded back was tried in the Superior Court, where the jury found that there had been no breach of lease.
Where we have two fact finders and the evidence could be read either way, don't we have case law that allows inconsistent results between the underlying causes of action and a 93A outcome?
We do. I'd say two things about that, Your Honor. First of all, taking the judge's findings, they do not amount to a 93A violation. What we have here is a eviction conducted pursuant to lawful order at the time it was conducted, and demolition conducted pursuant to permit. And we've cited to the court the Buster versus Moore case. I think Buster versus Moore makes it clear that on those facts, and one more fact the judge found that's really important, the judge found that 331 Lafayette was motivated by maintaining its construction schedule. That's a legitimate business motivation, which takes this out of 93A. The Buster case basically said that even in the Buster case, the defendant had acquired a note that the plaintiff was the obligor on for the principal purpose of using it as leverage to force that party to stop objecting to development of Moore's land. And the Judge Gant, as a trial judge, said, well, there was also a legitimate business purpose in acquiring and foreclosing on this note. Under those circumstances, we're not going to find a 93A violation.
Can I ask you a question, if I may intervene just for a moment, because it seems to me that the judge found additional facts that would be outside what you've described as a lawful purpose. And so, of course, the demolition was conducted pursuant to lawfully obtained permits, understood. But in this case, the judge found that the demolition, the way it was carried out, caused significant harm to the pizza restaurant and to the business by prohibiting customers from being able to park, but by prohibiting access to dumpsters, by prohibiting access of supply trucks, etc. So how are any of those facts that the judge relied on, how do they fall within a lawful business purpose?
Well, if they were anything, they would be a breach of contract, a breach of the lease. The jury happened to find no breach of lease, but wrongful conduct that causes injury, particularly conduct that amounts essentially to a breach of contract that doesn't have an extortionary quality to it, which is what in cases before Buster say, would not amount to a 93A violation.
Well, the judge found there was that quality to it.
I don't believe, Your Honor, she really did. I think that the findings the judge had was that this was improper, that it caused injury, but causing injury, an extortionary quality would be if she'd made a finding that either you vacate right now or I'm going to make your life miserable. There's no evidence of that, and there's no finding of that. I mean,
why wouldn't the fact that their lives, arguably, the lives of the plaintiffs here was miserable, that they could no longer operate their business as a result of the manner in which the demolition process was carried out?
Again, that would amount to a breach of contract, not 93A. It is, breaches of contract, and again, the jury found there was none, but breaches of contract may make somebody's life miserable. But again, if they don't have this extortionary quality that our case law talks about, it's not a 93A violation. We recognize that, our case law quite articulately states that parties are entitled to pursue their own personal interest, and that there may be times when pursuing that interest is detrimental to somebody else. But unless there is this extortionary quality, a breach of contract, and again, there was none here, there was none found by the jury, a breach of contract does not amount to a 93A violation. And that's what this case is. That's
why we have to be in an either or situation here. Why can't the new landlord want to stay on schedule, but also at the same time be using those activities vigorously, like by blocking off the parking, to create such terrible conditions that the tenant will move before the eviction proceeding concludes?
Well, one, that didn't happen. Two, they continued to conduct business.
Well, they didn't move, but that was apparently, some effort was made on your client's part to cause them to want to move.
There's not a finding of that, Your Honor. There is a finding that they were trying to keep their business schedule, but there's not a finding that there was a coercive, extortionary basis of what was done. And again,
I don't understand why when you say that, because removing their sign, blocking their parking, making it hard to receive deliveries. I don't understand why any of that goes to your client keeping its schedule versus trying to push these people out in breach of, to gain an advantage.
Well, again, I said the judge did not make that finding, and there was no testimony that was its purpose, that there was no testimony anywhere that this was done for the purpose of driving them out, and the judge having heard.
But you don't need specific testimony for the judge to make those findings and make those inferences from the evidence, right?
But she didn't do that. She made the inference that their purpose.
I don't know if I agree completely. I think there's a reason why she made reference to those particular events.
Well, she found them to be violations, but again, she did not find any place that 331 was engaged in these activities for the purpose of driving them out. She found that they engaged in these activities because they wanted to maintain their construction schedule. Repeatedly, she found that. If the findings had been that 331 went to Fran and Diane's and said, "You move out, or I'm going to crush your business," or if the findings had been that I conclude based on this that the purpose they had was to accelerate the eviction, but that finding wasn't made. In fact, what she found was that 331 believed it was going to get its eviction because it believed, and that Mr. Burritt's principal had never seen and was not aware and did not in good faith believe that there could be an oral extension. So they were going about achieving eviction by the lawful process of bringing an eviction proceeding. And so, again, I think under the Buster case, so long as there is a valid business reason for doing so, and they operate in accordance with the legal process, that can't be a 93A violation.
Well, I guess my question is, how far do we take that? I mean, if they had their their legal process that they were observing, and they had the permit schedule they wanted to meet, but they also wanted to make life as miserable as possible so that these people would leave. Why wouldn't that be a 93A violation? Why can't you have two motives at the same time?
Well, under Buster, if you have two motives at the same time, and if one of them is a proper business purpose, there's no 93A violation. You remember in the Buster case, one of the motivations of the defendant was to use as leverage the collection of the note to discourage pursuit of an administrative appeal. You know, that's kind of something, we've got a policy statute in terms of the anti-SLAPP that says we protect that policy, but Judge Gantz is a trial judge in the SJC in ruling on it said, notwithstanding the fact that that was one of the motives, and that was the primary motive, the fact that there was a legitimate, valid business purpose took that out of being a 93A violation. And I think that the record doesn't support, and the findings were not made, that there was that this was done for the purpose of driving them out. But even if it had been there, the fact that there's a specific finding that the motivation was the legitimate business purpose of maintaining a construction schedule under Buster would preclude this from being a 93A violation. May I address the damage component for a moment? Because the damage issue is—
Before you go to the damages, the trial judge referenced in Exhibit 37 as something that was allegedly concealed from the district court. Do you know where that is in our record? Because I was having trouble finding it.
I don't know. I don't recall her saying any specific exhibit was concealed. She also makes a mistake. There was a trial book with page numbers, and she sometimes calls an exhibit by a number that it's not. I would say that the trial judge also said she doesn't know what occurred in front of the district court. And the fact of the matter is when you look at the district court decision and you look at the decision of the appellate division, it's clear nothing was concealed. They know fully, completely and fully, they understood what the decision, what the position of the appellant FRAN and Diane's was. And in fact,
I think we should leave that there because I do have questions on the damages component, and you seem to have some messages you would like to deliver on the damages component.
Yeah, all three components of the damages are based on speculation. There is an absolute leap of logic that the judge finds in 2014 and 2015 there were losses and then awards a lost profit.
So, but on that question though, as I understood the judge's findings, she was saying that Fran and Diana paid themselves some money every year, and after they did that, they operated at a loss. Did I misunderstand that?
Well, she said that they paid themselves some money. There's no evidence of what amount they paid themselves as money. And it would be a curious result to award them that, because if that's what they did, it's tax fraud. So we have no record of that. We have no record. There's no record of this business ever being profitable, or when it was profitable for 2 years at less than $900 a month. So she built on this.
Well, you're making that argument though, you're saying they were operating at a loss after depreciation, right?
For most years, depreciation didn't matter. Depreciation is a real loss, but for most years, they lost irrespective of depreciation. And for 2 years, they had would have amounted to a profit of, I think, $900 a month if you don't count for depreciation. But depreciation is real because you got to replace equipment at some time. It's a real accounting factor. It's not just a fictional number. So I see my time is up, but each of the components, as we've said in our brief, of the damage are built on utter speculation. There is no record to support any of it. And the depreciation number is obtained by simply disregarding federal tax law.
So I want to ask you about the co-defendant settlement, because the tenants basically argue that there was a separate judgment against the prior owner and specific elements of damages assessed related to that. And so at most, you don't account for that, and that at most you would be entitled to a $3,000 credit for the settlement payment that went towards joint and several liability. What do you say to that?
That's not what the statute says. The statute says the sum paid for the release is what the co-defendant gets credit for. They allocated, they tried to do a contrived allocation that applied, there's greater number of legal fees that were awarded to the against Lee family than was awarded against 331. And with respect to those greater amount of legal fees, they try to allocate the settlement to that. But the statute says that it is to be, it is the greater of, I believe, but the statute would apply directly that what was paid for the release, which in this case was the entire amount, is what gets credited against the judgment.
Okay, I think we're going to have to leave it there. We'll hear from the appellee.
Thank you, Your Honor.
Thank you, Your Honors. Mark Jacqueline on behalf of FRAN and DIANE'S. I'd like to begin with the 93A portion here. And where I disagree with counsel is it's not just the schedule issue, keeping on schedule. If that was the only issue, we would not have 93. He's correct. But it's the sum of the parts. It's the taking the sign down for no reason and throwing it next to the door of the restaurant. It's the blocking of the parking lot. It's the blocking access to a dumpster. It's the demolishing, doing asbestos abatement in the abutting parcels. It's taking down the abutting properties. But I think the key example.
So did the trial court judge actually find a constructive eviction?
The trial court judge did not use the word constructive eviction. What she said was, for the findings of fact, was that the actions of 331 and Robert Burr made the conditions unbearable between May 31st, 2016 and October 31st, 2016, when the execution for possession issued. That period of time made it impossible for this business to operate. What's telling is the green tarps that were put in front of this business, they were completely unnecessary to block this door. Exhibit 25 is a picture of the view from inside the restaurant out. And in transcript volume 2, pages 95 and 96, Mr. Burr was questioned on this very fact. Why did he block the door? And he told us that he had no choice because of the size of the barriers, that it just lines up that way. But when we look at the picture from inside out, you can see a break in those barriers, that he intentionally put an extra barrier up so that the front of this pizza shop was broken, was blocked rather. And that's an intentional act. That raises the level to egregiousness, to the rancid flavor of unfairness.
Did the judge make that finding?
The judge did make that finding in the voluminous number of facts that were found in the findings of fact.
Well, no, but all of the facts that you've identified would give rise to a cause of action for interference with the covenant of quiet enjoyment.
Yes.
And that is a traditional breach of contract remedy at law. I think the question I have, at least as to those activities, goes to where is the finding that those acts constituted not merely a breach of the covenant of quiet enjoyment, but a violation of Chapter 93A.
It's throughout the findings of fact and rulings of law that are dated October 22nd, 2019.
Well, I read those. I have to say my reading, it seemed to me what was animating the judge's view of the case more than any other single factor was her view that the position the landlord took on the renewal of the lease was untenable as a matter of law, and could only have been pressed in bad faith.
That is one issue, but this is a sum of the parts. I mean, the fact is that the trial judge got it right across the board. This isn't a scenario.
The trial judge got it right. The district court got it wrong, and the jury got it wrong.
Well, the appellate division got it right also of the district court when they found that waiver is a question of fact and sent it back for trial. So
we have different time periods. So I think what you're saying is, even assuming the judge, whether she got it wrong or right, anything after the physical eviction, that would be, you know, whether or not there was a lease question, but anything before that had to be essentially a constructive eviction or some sort of the rancid behavior you're describing, sufficient to create it, because she did find 93A liability, right? Is that what you're saying?
yes. So what she found was that Mr. Burr intentionally avoided asking the question, was there an extension? That he had Exhibit 51, which is the letter that says, are you renewing? And Mr. Ruggieri writes on it, yes, we're renewed, and attaches a check and sends it off.
Yeah, but one of the questions I had about that was that I can't tell that he sent the writing where he writes in the margin, you know, renewed, or did he just send a check, or did they have a conversation? But I can't see, where's the proof that the renewed was received by the landlord?
He cashed the check.
Well, yeah, but if he just sent a check, how does that show that the landlord saw the piece of paper where he wrote to a note to himself, I renewed?
The testimony was that, I believe there was testimony from Mr. Lee that indicated that he did receive it. This letter was produced by Mr. Lee as part of his production of documents. So it would have been received by him. He would have had no other way of getting it.
So what about the Buster case? Is he reading that case too broadly?
He is. First, the Buster case says that if you're operating under a valid eviction, then you're, well, a valid court order, then you can't be found liable under 93. But these actions all took place before the execution issued. They're relying upon a judgment that was under appeal. All the actions that took place prior to October 31st, 2016 are violations of 93A because they were not acting under a valid court order. They were actions used to create a wedge between the plaintiff's business and the defendant in hopes of putting them out of business.
Right, but he says, but we're excused for all of that because we wanted to stay on schedule with our big construction plan. So we had a legitimate purpose. And so if we were also had a nefarious purpose, that's okay.
I don't think Buster goes that far. It can't be if we also have a nefarious purpose where we're immune from liability. If only his actions were motivated by the scheduling, then I would agree that 93 wouldn't apply here. But those weren't his motivations. The trial judge found that he was motivated in part by anger. He was mad at the plaintiffs for getting in his way, for not just acquiescing to his demands and stepping aside.
Well, you're right, but that doesn't necessarily mean, though, that what he did was improper. I mean, he can have, that's the issue. You can have both things at the same time. So how do we decide which one is the one that controls? You can want to maintain your schedule and be irritated somebody's standing in your way, but why does that mean? How do we decide if you do have the proper purpose? Why do we disregard that?
Well, what did he do with that irritation? Was the irritation such that he took every step he could to act in the courts? Fine, but that's not how he acted on his irritation. What he did was he ripped the sign off the roof and threw it next to the front door. He blockaded the building with green tarps. He blocked the parking. He blocked the access to the dumpster. He destroyed all the property around it. He kept from the building department that when he applied for his demolition permits, he concealed from them that there was an operating pizza restaurant at the time. These acts rise to a level of, I think the case law uses rascality, and I would agree with that. This isn't just motivations of staying on track. These are motivations of trying to destroy this business from the inside out so that he could obtain his purpose. And if his only motivation was scheduling, so be it. But this goes all the way back to July 2015 when he first looked at the property, and he went to the newspaper and said he was being extorted after could be construed as a mediation between himself and an attorney for.
So counsel, Lafayette argues that the trial judge's subsidiary finding of fact that Mr. Burr acted on a good faith belief that the plaintiff had no written lease in effect precluded that basically that finding precludes a finding that the defendant knowingly and willingly violated 93A. What do you say to that?
He chose to believe that. He never asked Mr. Lee if he was a tenant at will, if FRAN and Diane's was a tenant at will. He never asked if there was an agreement to extend or a waiver of the written requirement to extend.
Pressing a legal claim that is not wholly without basis is not a bad faith position. I have a very difficult time understanding how, in the face of a written lease that says that renewal must be in writing and any waiver has to be in writing, a landlord, a successor landlord who relies on that or presses that as a basis for termination of the lease is acting in bad faith.
This goes back to the sum of the parts. If this was he was acting in bad faith because he ignored the fact that the tenant said, "Wait a minute, we have an agreement to move forward."
No, but he brought a claim. That claim was upheld by the district court, later vacated, but upheld by the district court. The fact that there is at least a colorable basis for that claim is itself corroborated by the fact that the Superior Court jury agreed with it as well. Even if the judge is correct as a matter of law, that ultimately the correct view of the landlord's position was that, or the tenant's position was that they had a renewed lease. I am really searching for a way to construe the attempt to enforce what seems to be a colorable claim to be an act of bad faith.
It's one of the acts of bad faith, yeah.
But it can't be any of the acts of bad faith if it's not bad faith.
Understood. But the Mr. Burr intentionally chose to disregard the fact that the tenant was making a claim that there was a waiver. He intentionally.
He's not bound by the tenant's position if it's not backed up by the documentation.
He is if it's intentionally ignoring of it. What Mr. Burr essentially did was say, "Mr. Lee, do you have the green cards?" "No." "Well, then they're tenants at will." That's what he did. He didn't say, "Well, did you have any agreement? How did you work this out?" My clients and the trial judge found, after having a front row seat to this trial, found that Mr. Ruggieri and his partner, Diane Hamlin, they paid the rent increases. They did what they did based upon Mr. Lee's verbal waiver of those two provisions that said, unless you're leaving or selling the business, you don't have to let me know, just keep paying the rent. And that's what Judge Fahey found.
Even that agreement is consistent with doing so on a tenancy at will rather than a renewal of the written lease.
But the court found after trial.
The judge found that and the jury found otherwise.
But that there can be a waiver. You can waive the anti-waiver provision and you can waive the written requirements of a lease if parties agree to it, which they did in this.
And ultimately that is on the question of whether there is a breach of the lease is a question of fact for the fact finder. The jury found otherwise. The judge, for purposes of 93A, found that there was a breach of the lease, and in order for that to be a violation of 93A, had also to find or conclude that that was in bad faith. I don't understand how they can do that when there is a basis in the documentation that the jury agreed with. I'm struggling to find that. Now you say, well, that wasn't the only bad faith. So even if that was not in bad faith, you've got all of the construction activity. And you know that raises a separate set of questions. But again, I think you've got findings by the judge that are consistent with a legitimate business purpose there as well.
I respectfully disagree, Your Honor, and I, as I'm sure you would expect, but
we don't have to agree.
But I don't think Judge Fahey got it wrong here. She saw this trial. She saw the extent she had a 3-day evidentiary hearing on the waiver issue early in this case. She saw the entirety. She got to hear the testimony, weigh the credibility. Her decision does not rise to a level of clearly erroneous.
I had a couple of questions for you about damages. As to the evidence that the pizzeria made a profit of approximately $16,000 in 2016 after, years of losses, how is that consistent with your constructive eviction claim?
Because those occurred in the first 6 months of 2016.
Can you give me a record citation to show that those occurred in the first 6 months?
We cited to it in our brief. Transcript 3, page 103.
The defendant argues that the judge made a double count regarding the ventilation system, basically taking the amount of the deposit and applying it to the total of the project. What do you say to that?
I disagree. I think what the judge was doing was taking the equipment as a whole and trying to assess what the damages were regarding the equipment as a whole, and then from there, subtracting approximately 50% for the use of them. But I think what the judge was trying to do was to say, what's the base amount here for this business, taking the ventilation system, the ovens, the other equipment, putting the purchase value on them, and then subtracting out some level of use.
Were there 2 ovens or 3?
There were 2 ovens, I believe. And I know that the judge did say 3 ovens, but I believe there was just 2 ovens.
So the Lafayette argues that the economic benefit of depreciation would never be more than the taxable amount saved. So you wouldn't get 100% of the depreciation, you'd get some sort of tax rate applied to the savings. What do you say to that?
Well, it would all depend on if the business was sold, under the lease, it would be their final tax return that would dictate the value. If we're dealing with a capital gains number, that could be a significant amount. If we're dealing with, I would think that, in fact, the defendant in this case would have needed to put on some sort of rebuttal expert testimony in order to establish that depreciation was not a valuable asset.
I think they're arguing that I don't think they dispute it's a valuable asset, but you don't get 100%. You save taxes. So in other words, it reduces your income and then you pay a lower tax on your income.
That was the unused depreciation that they had. It wasn't, the judge does point out, I believe in a footnote in the findings of fact, that there wasn't an objection raised to that at the time and was therefore waived. It was not preserved. I would point out though to the damages issue that you pointed out.
If there are no further questions, I think we'll have to leave it there.
Thank you.
Thank you both.
Thank you, Your Honors.
We're live.
The last case on our list for argument today is case number 2019 P1297, ENID De Silva versus ALISANDE, Cunningham, SWEENEY, and another. Mr. Aleo, you may begin.
Good afternoon. Michael Alio for Ms. ALISANDE Cunningham Sweeney. This is an appeal, as you know, by ALISANDE Cunningham Sweeney of a decision by the Department of Industrial Accidents Reviewing Board that affirmed an award of workers' compensation benefits to Ms. DeSilvia for injuries that she suffered while living at the home of Ms. Cunningham Sweeney. On appeal, Ms. Cunningham Sweeney's position is that Ms. DeSilvia did not qualify for benefits for two reasons. First, that she did not qualify as an employee under the Workers' Compensation Act because she was a domestic servant who worked less than 16 hours per week. And second, even if she were an employee, that at the time she suffered her injuries, she was not acting within the course of her employment. The injury occurred in late January in the middle of a wintry night at approximately 11:30 p.m. When Ms. DeSilvia chose, for some reason, to take her personal trash from her own bedroom, where she kept her trash, outside, despite knowing that the conditions were icy. In so doing, she slipped and fell on an icy fire escape while taking her trash to the dumpster.
The fund argues that the administrative hearing judge made a finding of fact that she worked 30 to 40 hours per week, and that really answers your jurisdictional argument. And I understand your response to that to be, well, then we're just jumping from the frying pan to the fire because all this prior bad act evidence came in, and so you can't really use that finding. Am I understanding that correctly?
I think that essentially sums up a good portion of our argument. There's a separate aspect to our argument that because the issue of whether she's an employee is what we would call jurisdictional, and even separate from the jurisdictional aspect of it because it was clear error, that that the decision was arbitrary and capricious, that this court may review it anyway. But that's correct, Your Honor, that because of, and I'm sorry, I'm going to make it a little weedy, nuanced, because of the administrative error, the administrative judge's findings of fact were clearly prejudiced. And I can speak to the factual circumstances. The evidence overwhelmingly was in favor of Ms. Cunningham Sweeney on the issue of how many hours Ms. DeSilvia worked. The line of questioning, which perhaps I should detail for Your Honors now, that helped to lead the administrative judge to form the opinion that Ms. Cunningham Sweeney and the three witnesses that she called in support of herself at the administrative hearing, the administrative judge determined that none of them were credible, didn't explain it.
You're actually saying then that the administrative judge determined that the other witnesses were not credible just as a result of this line of questioning to Mr. Jepson, I believe the name is, am I correct?
That's correct.
The line of questioning that he had an altercation with one of the other employees at some point beforehand. It was not a major focus of his testimony, and the fund agrees that it shouldn't have been introduced, but and you think there's some sort of spillover effect that as a result of permitting that testimony, and therefore that's the reason why the judge discredited the testimony of all of your client's witnesses?
Your Honor, I absolutely do think so. There's just no other evidence in the record. It's a substantial record that was developed at the administrative hearing that either Mr. Jepson's testimony was not credible, the other witnesses who testified in support.
Well, his testimony is a bit, is not always direct. Would you agree with me on that? In other words, there were other reasons, I might say, why the judge might not have found him credible in all respects, other than this one line of questioning.
Your Honor, I would say, yes, he was not always direct. It sounds
he worked 12, 14 hours a day minimum. His descriptions of some of his activities might have led, or apparently in this case, probably did lead the administrative judge not to find him not credible.
Your Honor, I would characterize his testimony at times as a little bit rambling. He's a PCA, a personal care assistant, or he was at the time. He's working in Miss ALISANDE Cunningham's home, caring for Miss Alison Cunningham's mother, who has sadly since passed. Miss Cunningham Sweeney was not a business. You know, she wasn't operating a business per se. She was taking care of her mother, and so she had tenants that were living there. And it was like an odd circumstance, but for PCAs, these types of circumstances aren't too odd. My understanding is he'd never been.
What I guess I'm having some trouble putting together is if it was certainly credible that Mr. Jepson would work to between 12, 14, even more hours per day, given the nature of the situation, why wasn't it credible that Mr. Sylvia also worked more than 2 hours a day?
It's a great question, Your Honor. So just for context, the individuals, the PCAs who cared for Miss Cunningham Sweeney's mother were employees of a third party.
Stavros, yeah.
And from time to time, as to have an extra hand around the house, somebody who's not going to work as an employee, but who's just going to come live essentially as a tenant, or as the Workers' Compensation Act defines, a part-time domestic servant. Miss Cunningham Sweeney, in this circumstance, posted an ad on Craigslist for somebody to come.
Yeah, no, I'm familiar with the background, but I was just probing a little bit your basis for saying that that it was your interpretation that it was inappropriate, capricious, and arbitrary that the administrative judge here rejected the testimony of all of the witnesses presented by your client and instead found credible the employee.
So on that note, Your Honor, just Mr. Jepson was an employee of Stavros. He was the employee who looked after the home, other than Miss Alison Cunningham.
Right, working about 70 hours a week or so, he said, and being paid by Stavros for that, right?
He was paid by Stavros by the hour. He worked a ton. It was, you know, he had become, like so many employees do in these circumstances, like family. And so during the time period in question,
they said he had been there about 9 years, correct?
That sounds right, Your Honor. I'm sorry, I don't remember the exact. It was an extended period of time he had been there. He was the person who principally looked after the household. Miss Cunningham Sweeney had gone away during the period in question, but was in regular contact with Mr. Jepson. And so when she goes away, he takes care of the property. He's the person that takes care of the property.
You know, I don't want to get as far afield, because what I was questioning you about, and you've answered me, thank you, about the judge's prerogative to assess credibility. So then we have another question that has arisen, that the fund says that you actually should not, that you waive the issue as to whether or not Mr. Sylvia was a part-time domestic servant. And you indicate that no, you didn't, because the issue of whether or not there was an employee relationship was raised. But I've gone through the transcript pretty carefully, and I've looked at your cites to the transcript, and I can't see where in any place that's actually crystallized, and what the fund calls an affirmative defense, what you call a jurisdictional issue, is really before the judge. Can you help me out there?
I can, and Your Honor, if you'd forgive me, I want to answer your question about the issue not being raised. Just, I fear I'll forget to come back to one last point I'd like to make about the credibility issue.
Sure.
Forgive me, I don't want to delay getting to
it. All right.
Just in the course of Mr. Sylvia's counsel's efforts to examine Mr. Jepson about his criminal charges, over the objection both of Ms. Cunningham Sweeney's counsel, was not my firm at the time, but over the objection of Ms. Cunningham Sweeney's counsel, as well as counsel for the Workers' Compensation Trust Fund, Mr. Sylvia's counsel persisted in trying to have the police report admitted. And in so doing, Mr. Sylvia's attorney said not only is credibility at issue, character of the farm is at issue, and the home was generically referred to as the farm. So it clearly refers to Ms. Alison Cunningham Sweeney, and the judge responded, "Oh, I get that." You know, so it was clear to the judge that these credibility issues didn't just go to Mr. Jepson. It went to the farm generally, or AKA, you know, Ms. Cunningham Sweeney.
I see your point.
On your issue, Your Honor, our position is in terms of whether the defense was raised. And the only reason the reviewing board didn't probe this issue of prejudice was because of its just determination that the defense had been waived. Under the Workers' Compensation Act, in Section 1, which is entitled Definitions, what the trust fund is referring to as an affirmative defense. But the definition of a part-time domestic servant, as well as the exemption from the duty to cover such a part-time domestic servant, is included under the definition of employee. And our position is that, yeah, it could have been better probed at the administrative hearing. There's no doubt. Had I gone back and done it on behalf of Ms. Cunningham Sweeney, particularly in hindsight, I would have done it differently. That said, the definition of employee includes part-time domestic servant. It includes what's been referred to as an affirmative defense. It's undisputed. The trust fund, as well as the reviewing board, they don't deny that the issue of whether she was an employee was raised. It could have been raised more perfectly, it's true, but it was raised.
I don't understand that argument, because in raising a challenge to the status as an employee, you also are disputing her status as a part-time employee, because part-time employees are included within the definition of employee. So not only did you not zero in to identify the claim that she was only part-time, but in saying that she was not an employee, you were specifically arguing that she was neither a full-time nor a part-time employee.
She was not a full-time employee or a part-time employee. She was a different type of employee defined under the Act.
But your argument now is that she was a part-time employee only and therefore exempt, and that's a completely different argument. I don't see how raising the claim that she was not an employee in any way brought this issue before the administrative judge.
The issue before the administrative judge was whether she was an employee, which for the purposes of the Act, it's whether she's an employee who's entitled to coverage under the Act. The Act itself defines—
But you didn't say whether she was an employee entitled to coverage. You said she was not an employee. Never in the proceedings before the administrative judge did you say that she was an employee who worked fewer than 16 hours a week.
And Your Honor, I don't disagree that it could have been raised more clearly and better, but the facts that were disputed went exactly to that point. And it gets me to the other issue, which is that the reviewing board, as well as this court, can overturn a decision that's arbitrary and capricious, that's in clear error. And then when you combine the administrative judge's evidentiary errors, which not only go to this issue, but also go to whether the injury arose within the course of employment. And the reviewing board spells it out. The reviewing board says that the evidentiary error may have impacted the determination as to how many hours the individual worked, as well as whether the individual was still employed at the time that the injury happened. So then whether you consider Ms. DeSilvia an employee at all after the first couple of days of work, if she's not an employee, obviously, then she couldn't have been injured in the course of her employment. But as well, the administrative judge did consider the issue of whether she was injured within the course of her employment at the time of the injury. And Your Honor, I am running out of time. I just want to emphasize that there was extensive testimony about how trash should be taken out or must be taken out within the house.
Yeah, that was very, very insightful. In terms of that, I have a question about something you just mentioned, which is the issue as to whether or not the accident occurred during the arising out of or in the course of her employment. And the fund argues that that was not actually raised before the reviewing board, that you did not raise that issue there. And I didn't actually, and correct me if I'm wrong, see you combat that point in your reply brief. So what is your response to that argument?
Unfortunately, Your Honor, I was not representing the appellant at that stage. So I don't know.
This is not per person thing. Just what was the issue? Was the issue raised before the reviewing board?
The reviewing board addressed it in part, but stated that the issue was not raised before the reviewing board. Our position again would be that it's reviewable at this stage because aside from the fact that the facts make it abundantly clear that there's no way, as a matter of law, you could interpret this to have arisen within the course of employment. But that it goes to this level of arbitrary capriciousness that was impacted by the clear error that would permit the court to review it at this point.
Right.
I have more to say about that, but I see that my time is
That's okay. There's your brief as well, but you answered my question. Thank you.
Thank you.
Thank you.
Mr. Martland?
Good afternoon. May it please the court. Douglas Martland, Assistant Attorney General for the Trust Fund. The employer here cannot establish an error of law by the reviewing board because it has clear authority under case of Phillips to treat an unraised affirmative defense as waived. Likewise, its waiver determination wasn't an abuse of discretion because here all defenses to a workers' compensation claim must be raised before the administrative judge in the first instance. And here the employer failed.
Counsel, he says this is really jurisdictional and that the board had to satisfy itself that that the person in question fell within the act. What do you say to that?
This is not a jurisdictional issue. We cite two cases in our brief, Brewer's case and Madriaga's case, that make clear whether a party is a domestic servant is a question of fact, not a jurisdictional issue. And here, regardless, Your Honor, we are in the proper jurisdiction, the Department of Industrial Accidents, for a workplace injury. Here, the employer was on notice at the outset of the proceeding when it was joined to the proceeding by the trust fund that it was the employer of an employee that was injured at the workplace. It certainly should have raised all its affirmative defenses, both by regulation, case law, and Chapter 152, Section 7. That would include the defense that this particular worker was a domestic servant working less than 16 hours per week and that the employer had elected not to provide her workers' compensation insurance. They didn't do that at the November 2014 hearing. They didn't do that in their July 2015 effort to file a late appeal. And they didn't do it again in September 2015, either at the resumption of the hearing or in the memorandum that they submitted that day. Instead, they focused entirely on a separate issue of whether or not this worker was in fact an employee at all at the time of the injury, because apparently they'd attempted to terminate her employment. Addressing briefly the issue of Mr. Jepson, here the reviewing board appropriately determined that any error was harmless because his testimony went to the issue of whether there was an employee-employer relationship at all, an issue that the employer ultimately conceded before the reviewing board. If there are no,
with the fact that the judge in fact found that she worked some 30 to 40 hours a week, then which then raises this issue about how many hours the person worked, and that the reviewing board seems to think that had a significant impact on that issue.
Your Honor, I would certainly agree that if the affirmative defense of domestic servant, this employee being a domestic servant working less than 16 hours a week, had been raised, there would be more of a concern about Mr. Jepson's testimony. But here, as the reviewing board explained, that defense was waived, and any other issue that his testimony went to was ultimately conceded on appeal by the employer. That goes to both whether there was an employment relationship at all and the fact that she was working, the employer admitted, 14 hours per week. So again, there was no harm. If there are no further questions, I'd ask this court to affirm the reviewing board's determination.
So if her duties were only to sit with the employer's mother and did not involve cleaning of any kind, when she was emptying the trash from her room, would that be in the scope of her employment?
But that's not the facts of this case, and that issue separately was waived by the employer here because they did not raise that particular defense before the reviewing board. The three issues that they raised before the
No,
reviewing
I
board.
do understand that the issue was not waived, but he's arguing that basically you're just saying if you're in the house, there's no boundary to when you're acting in the scope of your duties. And I'm trying to test the limits of that. So I realize I'm posing a hypothetical, but that is the point, to pose a hypothetical. What if she had no cleaning? You rely heavily on that she had some light cleaning duties. So I'm like, what if we take that away and she's just emptying the trash from her room? Would she be acting in the scope of her employment?
Well, separately, Your Honor, and to answer perhaps your hypothetical, the administrative judge's finding here was that this particular duty was within the scope of this employee's workplace duties. And that's a finding that should not be disturbed by this court on appeal. To answer, as I understand your hypothetical, which is if we had a separate set of facts where that was not within her duties, that would be a different question, but that's not the question that we have here. There's a clear finding by the administrative judge that this was within the scope of her duties. It's not an issue that can be challenged on appeal. And therefore, and also separately.
Well, again, I'm trying to test the limits of that. If I think everybody testified she was supposed to just put the trash outside her door. If she decided not to do that, is that still within the scope of her duties?
If ultimately the finding here by the administrative judge was that her duties were limited to sitting with the mother, which is not what the finding was here, I would agree with you that we would have a different issue, Your Honor. And that perhaps—
Well, that's why I'm pressing you, because many citizens of the Commonwealth employ people to visit or sit with elderly relatives, and they need to understand the scope of their liability, or what the trust fund would say is their liability. And so they need to define duties very carefully. And I'm trying to understand if an employer says you are to, put the trash out by putting it outside your door, and the person decides to disregard what they were told to do and to do it a different way, because everybody's got to do it my way these days, then would that be something that could cause the employer to be liable?
Again, Your Honor, I think it depends on the facts and circumstances of the scenario. Under your hypothetical, it is much less likely that an employer would be liable on those facts where it was not part of the injured worker's duties. But again, that's not the facts of this case. And separately, there's a separate issue even on the affirmative defense on the domestic servant point. And I think your question hit the nail on the head when you described very aptly that the employer and the employer here should have put these duties in writing. They're not, and we're reliant entirely on the competing testimony of both parties. But that's an entirely separate question that, again, is not on the scope of appeal here. If there are no further questions, I'd ask the court.
No, I wanted just to clarify that you do say in your brief that this issue of whether or not the accident, the injury occurred during the course of employment was not raised before the reviewing board. Of course, it was raised before the administrative judge, but not before the reviewing board, and therefore you say that's why it's waived in terms of our review.
Exactly, that they failed to raise it before the reviewing board. The three issues before the reviewing board were the affirmative defense, Mr. Jepson's testimony, and then a separate due process argument that's not even raised here. They did not raise the new argument that they're raising here regarding the scope of their duties. But I would agree with you, Justice Vuono, that was raised before the administrator.
Right. Yeah.
So to go back to where I started with your learned colleague, his argument though is that the prior bad act situation takes you from the frying pan to the fire, because it was very prejudicial to allow the prior bad act testimony, and that it fed into this finding that she worked 30 to 40 hours per week. So why doesn't it does get you out of the how many hours did she work problem, but why doesn't it feed into a problem on the other end, which is that it caused these credibility determinations that really affected the whole outcome here?
I think what is clear from the reviewing board's decision, Your Honor, is that they very carefully read the transcript and the witness testimony from all of the witnesses and reached a conclusion here that both Mr. Jepson's testimony, as well as all of the other employer's witnesses, primarily went to the issue of whether there was an employment relationship at all. Mr. Jepson's testimony repeatedly comes back to the point of this individual was not an employee on the date of the injury because we terminated.
Right, but I guess that's my concern, because when you take the prior bad act evidence that the reviewing board definitely says was improper, right? So now, you know, the analogy that all trial attorneys use is that you found a piece of rancid meat in your stew and you don't eat around it, you throw the whole thing out. And so they say, look, this guy whose credibility is the farm's credibility is shot. There's nothing here, so all the findings are now going to go against him.
And again, Your Honor, I think the reviewing board also considered that point as well. And they explained that because during the oral argument before the reviewing board, that the employer conceded that there was an employment relationship and that the employee was working for up to 14 hours per week, that there was no harm to the employer from this particular decision on impeachment by the administrative judge. And again, what the upshot of that is, even if the administrative judge had accepted all of Mr. Jepson's testimony, the employer conceded the exact opposite point during the proceeding with the reviewing board. And that again establishes that any error was harmful. If there are no further questions, I just again ask the court to affirm the reviewing board's determination.
Okay.
Seeing none this time, I will consider the matter concluded. The case is submitted to the panel and